Hello, hello, hello. Good evening. How is everyone? Before we get started with the trial, I want to show you a video I found today. We'll watch that first and then we'll get right into the trial.
Tonight, a Georgia man is standing trial for the murder of his wife.
Tonight, the trial continues for a man accused in the cold case murder of his wife.
Tonight, a Georgia man is standing trial for the murder of his wife, who was also the daughter of a convicted serial killer. Opening statements got underway today in the case against Christopher Wolfenbarger. This is an update to a story we've covered for years here on Channel 2 Action News. Channel 2 investigative reporter Mark Winnie live for us now at the Fulton County Courthouse. And Mark, this case stretches back decades.
Yeah, I've been involved with this since 2003. The Bible talks about the sins of the fathers. Well, a court document says Melissa Wolfenbarger's remains were discovered in April and June of 1999, and that they were identified via dental records in March of 2003. And that's where Melissa's father, being a serial killer, becomes important.
What triggered the identification ultimately is the arrest of Melissa Wolfenbarger's father.
A cold case solved in 2003 involving 5 murders is now inextricably involved with another cold case murder for which Christopher Wolfenbarger is on trial this week in Fulton County Superior Court.
There is no evidence of these charges in this case, and that's why we will ask you at the end of this case to return a verdict of not guilty.
Carl Patton Jr. was the man arrested in 2003. We're told Melissa Wolfenbarger was his daughter, who had been the wife of Christopher Wolfenbarger. He was charged in a 2024 indictment with her murder.
Melissa's father, Carl Patton, committed a string of murders in the late 1970s.
We were there in 2003 when serial killer Carl Patton Jr. was unloaded in the custody of the Fayette County Sheriff's Office, already suspected of 4 killings in the 1970s, known as the Flint River murders, because the first 2 bodies discovered were found in or by the Flint River. Says retired lawman Bruce Jordan, who told us he led the investigation into Patton as the chief investigator for the Fayette County Sheriff's Office.
He pled guilty to 2 murders in Clayton County, 2 in DeKalb County, and 1 in Henry County.
Jordan says around the time Patton pled guilty to the 4 murders to which authorities had already connected him in Clayton and DeKalb counties, he told Jordan and prosecutors he had also killed a man in Henry County. And in that same meeting, he turned to Jordan with a request.
He said, my daughter's been missing for years, and he said, I didn't kill her. Would you put the time into finding her that you did finding me? I said, well, I can try it.
In a 2003 story, we talked about how Carl's wife, Norma Patton, said she had turned to Jordan for help to look for her daughter, Melissa.
She stopped me and said, now, would you help find my daughter?
He seems sincere.
Jordan says he went from one Metro Atlanta medical examiner's office to the next, looking for an unidentified body that might be Melissa. And later on the same day, he visited the Fulton County medical examiner's office. A GBI agent called him and said authorities had checked her dental records against a skull they had, and it was Melissa.
At some point in time, I no longer had standing in the fight.
Jordan says since he has been subpoenaed in the trial of Melissa's husband, Christopher, he's limited in what he can say, but because her remains were discovered in Atlanta, the case belonged to Atlanta police, who announced in 2024 they had arrested Christopher Wolfenbarger. We talked to Deputy District Attorney Vincent Fawcett last year.
I think the key definitely was the ability to re-interview witnesses and line the facts up to create the case. It's a circumstantial evidence case, but most cases are based on circumstantial evidence.
The extent of her suffering in life and in death had nothing to do with Christopher.
And at the end, that was defense lawyer Joel McDermott. Now, we're expecting Norma Patton to be a witness in this case. And from the defense's opening statement, I wouldn't be surprised if they go after her hard in cross-examination. Reporting live outside the Fulton County Courthouse, Mark Winnie, Channel 2 Action News.
And we'll be seeing what that cross-examination and that trial looks like. Mark Winnie live for us again, covering it for years. You've been doing this. Thank you.
Sure.
What do y'all think? Especially the mother and the family did not see any signs that the father could be a serial killer. I believe that the father did not do it. And then whenever he was even arrested, he begged them to look into her case. So let's start watching the trial.
Okay. Madam Court Reporter, are you ready? Madam Court Reporter, are you ready? Yes. State ready? Yes, sir. Mr. McDermott, is the defense ready?
We're ready.
Okay. Okay, this is going to be Thursday, August the 21st, in the trial of the State of Georgia versus Christopher Wolfenbarger, case number 24 SC 004201. I'll note for the record that Mr. Wolfenbarger is present here in the courtroom along with his counsel, and that the state's counsel is also present here in the room. I have a couple of questions just in terms of logistics. At the end of the day yesterday, I had asked if the state was going to rest. Is that the expectation, or do we expect that we're going to have some more witnesses from the state?
State's going to rest.
Okay. Will there be motions that I need to take up from the defense, or here's what I ask. Logistically, I'd really like to go directly into the state rests. Defense, call your first witness if I can.
We have a motion, but we don't mind doing it just very quickly, and then at the lunch break, expand on it, as long as there's no waiver or contention that we didn't properly raise it. I mean, we do that in federal court all the time, say, we are hereby, moving for directed verdict on every count, on every element. And we just agree that we'll expand on it, when the jury's not having to wait.
Seems fair. Mr. Blessett, you agree? Okay. So if I bring the jury out right now, and you've already reserved your right to move for directed verdict, if I say state, call your first witness, and get your next witness, and you say the state rests, Mr. McDermott, you ready to call your first witness? Okay.
Witnesses are here,
Okay.
but two of them are in restrooms. So we'll just need a few more minutes. I sent in my bench warrant to
It's been approved and signed. I don't know if it's been filed. Yet, or if it's been sent back to you, but I'm aware of it and I have signed it.
is that
What do we need to do in order to get the sheriff?
That is a question for Ms. German. So let me find out where she is in status and who she's notified. Ms. German, when you get a moment, if you could, one, let me into the Zoom, and two, come here for just a moment, please. Thank you.
So,
Whether it's been accepted that you can then present to the sheriff. She's also going to call upstairs to the sheriff and let them know that that request has been made.
So I'm required to take it to the sheriff.
I believe that the defense is required to make that request, but we are also notifying the sheriff of the request.
Thank you. I guess all I'm saying is, I might just share it through it. Instead of looking through the whole again.
Mr. McDermott?
I have one moment, Your Honor.
Yes. Thank you all. Please be seated. Good morning. Thank you. Thank you for your patience this morning. We are ready to go ahead and get started. Mr. Fossett, the state may call its next witness.
Yes, Your Honor. You got this time to state the rest of this case.
Okay, thank you. Mr. McDermott, defense may call its first witness.
We did the motion already.
Yes, sir.
Okay. At this time, the defense calls Kimberly Cameron.
Okay. Come on up to the witness stand, please, ma'am. And when you get there, before you have a seat, if you'll turn around and face the deputy and raise your right hand, he'll swear you in, okay?
You swear to answer the testimony that you're about to give. That question is that you got.
And ma'am, if you'll do me a favor and scoot up to the microphone, get situated however you feel comfortable, but make sure you're close enough to the microphone that you can speak into it, because I can already tell you're a little bit soft-spoken. And state and spell your name for the record, okay?
Kimberly Cameron, Kimberlycambron.
Okay, and also we will remind you to try to talk more slowly because the court reporter needs to take down everything you say. And I will add a caution the judge has given other witnesses that there's a ledge right by your chair, so be careful not to roll off to the side too much.
That is true.
All right. Now, Ms. Cameron, do you know the defendant?
I do.
How do you know him?
It's my brother.
And did you know Melissa Wolfenbarger?
Yes.
And how did you know her?
She was married to my brother.
Okay. And did you know her while she was alive?
I did.
Did you spend time around her?
Yes.
Okay. And how and where did you spend time around her?
When they were married, they lived with my grandmother. So I would go there and spend time with her.
And would you do that frequently?
Yes.
So you suffice it to say you spent quite a bit of time around Melissa.
Yes.
Do you remember any episodes growing up with her that stick out in your mind?
Yes. I remember when I was learning to drive, I was so nervous that every time I would drive, I would go over to the side of the road.
You would pull over?
Well, when a car was coming toward me, I was afraid that I was going to hit that car. And so I would pull over and she would calm me down.
Do you remember when Melissa was pregnant
Yes.
with Christy,
Yes.
and then about a year later with Joey?
Yes.
And do you remember her having discussions about the custody of those children?
I do.
And do you remember what she ultimately chose as far as the decision in that regard?
She decided to give custody to my mom.
And why did she discuss her other parents?
She did, and she said that she did not want her mother or the state to have her children.
Did she at any time give you a reason why she didn't want her children with her parents?
She did. She just she did not elaborate. She just said that they were not good people.
And you said you visited Melissa multiple times because she lived at your grandparents' house, correct?
Correct.
And you went over there multiple times. Were you generally over there during the holidays?
Yes.
Was it?
Yes.
Do you remember, you spent most of the holidays with Melissa then, correct?
Correct.
Do you remember if Melissa at any time called her mother on a holiday?
Not to my knowledge.
Do you remember her calling her mother anytime?
Not to my knowledge, no.
Do you remember her writing letters or cards to her parents?
No, not to my knowledge.
Just a minute, Your Honor. Sure. No further questions, Your Honor.
Thank you. Questions for this witness? Yes.
Good morning, Ms. Cameron. How are you?
Good morning, good, and you?
I'm doing well. Thank you for asking. You just testified that Melissa told you she did not want her parents to have her children. Is that fair?
Yes.
Okay. What year was this? Do you remember having these conversations with Melissa?
I don't remember it exactly, but it was between 96-ish.
Okay, 96. All right. Permission to approach, Your Honor? Sure. I want to approach with husband and witness statement number 71, and I want you to read this entire letter out loud of statement number 71.
Dear Mom, hello. It's been a while since that.
Hang on. Sorry. Yeah. If you would just try and read it a little bit slowly, especially when we're reading things, we have a tendency to speed up. And again, the court reporter has to take it down. Okay. Thank you.
Dear Mom, hello. It's been a while since that weekend that I last talked to you. I thought that I would write you a letter. I'm okay. Here are some pictures of Chrissy, 7.5 months. Can you, I'm not sure what that one says. Please.
Does it say you can pass them out?
Yes, sorry. You can pass them out if you wish, but it won't. For
Does
the
it say
fact.
if it wasn't for the fact that Kathy was there when I got them, she would not have gotten any.
She would not have gotten any of them. She wanted me to give Chris's grandmother the biggest one, but I didn't. And she got mad at me, but oh well. They are both getting on my nerves. They act as if Chrissy is their daughter and not mine. And there is something that I need to tell you, and I really don't know how. So I will tell you like this. And do you want me to continue?
Yes, please.
You will sooner than you think have another grandchild. July 27th is the due date. Do not be mad because you are not the only one just finding out. Please. Not sure.
Does it please don't rub it in, mentioning something like you know how hard it is to take care of two kids so close in age, like Kimberly and JC?
A few days. Other girl. No names have been picked out yet, and I know not what to expect at baby shower, so I won't ask, but feel free. And with this one, I have planned to let you have a part of his or her life, who says Chris has to know, and when we move, we will do the same to Kathy and family that Chris did to you and Dad. No part in Chrissy and baby's life. Chris don't like you. Well, I don't like Kathy or Virginia, but Kimberly and I get along pretty good. Every time she hears her mom say something about me, she sticks up for me and tells me about it. I remember telling that Kathy said that she wishes me and Chris would move away. Kimberly says to her that if she moves, that Chrissy would move with us. Kathy said no, she won't either. And Kimberly, she is their daughter. Then Kathy said no, she isn't. If someone said that about you, you would be mad. So I told Chris, and Chris got mad. When Kathy asked to take Chrissy off, Chris said no, she better be here when I get back. And Kathy got mad, and I laughed. You probably think this is stupid, but if you had someone trying to be mother to your daughter, you would get mad too. And when we do move, they are not going to know where we are living. And every time they go off, they have to take Chrissy and don't even ask. They get her all ready and leave. I'm supposed to have my own car soon. Then I will bring Chrissy and let you see her. Bye for now, Melissa.
And this is a letter that Chrissy wrote to her mother. Is that fair to say from what you read?
I'm sorry, could you repeat the question?
Sure. Does it appear from what you read that's a letter that Chrissy wrote to her mother?
This is a letter that Chrissy wrote to her mother.
A letter that Melissa wrote to her mother.
In my opinion, it doesn't sound like Melissa, but it does state her name on there.
It is signed by her.
Yes, it says bye for now, Melissa.
And so in that letter, Melissa actually wanted her mother to at least spend time with her children. Is that fair to say?
In that letter,
Is it fair to say that she actually would have preferred her mother to have her children rather than Kathy, who's your mother? Is that fair to say?
again, in that letter.
Now, you also, I think, discussed on direct examination that you were not aware of any cards that Melissa sent to her mother.
No.
Answer out loud, thank you.
Permission to approach?
Go ahead.
I'm going to show you what's already been admitted. It says it's 67, 68, 69, and 70. You take a moment to get those. And I'm going to So I want to first look at 67. Is this a letter addressed to Norma Patton?
Yes,
And is your understanding Norma Patton is Melissa's mother?
yes,
And does it say birthday?
yes,
And does it say happy birthday?
yes,
And 97 with an asterisk?
yes,
And does it say love you, Chrissy and Joey?
yes,
And it's Chrissy and Joey, Melissa and Chrissy's children.
yes,
Looking at Stacey's Exhibit 68, is that addressed to Carl and Norma Patton?
yes,
Right. And does it say anniversary?
yes,
And does it say Melissa Wolfenbarger at the top?
yes,
And is Melissa their daughter?
yes,
And does this letter or two cards say on side special anniversary, which is to a very special couple, have a happy anniversary, love Melissa, Chrissy, and Joey?
yes,
And does it read in handwriting, happy anniversary, this year I'm going to take you out to lunch. My only day off is June 6th. Meet us there at 11:45 to 12 at Ryan's. You and Dad can bring JC and Kimberly.
yes,
Does this appear to be a letter or a card sent by Melissa to her parents for their anniversary?
yes, it appears to be.
Now showing you Stacey's Exhibit 69. Does this say, appear to be a Father's Day card?
Yes,
Does it say for a dad who means so much?
yes,
It means so much to know our family can always depend on you.
yes,
Have a very happy Father's Day.
yes,
Love, Melissa.
yes,
Does the card further read, Dad, with all the things you have to take care of, you always take care of your family first.
yes,
And on the back, does it say, a father's love is a promise made deep in the heart of a man, a promise to care for his family that keeps every day of his life.
yes,
Is this also signed by Melissa?
yes,
And was it sent to her father, Carl Patton?
yes,
Stacey's Exhibit number 70. Is this a Mother's Day card?
it says Mother's Day, yes,
Does it say, is it addressed to Norma Patton?
yes,
Does the card read, it is the only thing in the house that doesn't have to be swept, polished, watered, cooked, picked up after, or washed behind the ears? Relax and have a happy Mother's Day, Melissa.
yes,
And right, appears in handwriting. Next Wednesday, May 14th, I would like to take you and Daddy out for lunch. I'll give you your Mother's Day present then.
yes,
And these all appear to be cards either from Melissa or Melissa writing cards on behalf of Chrissy and Joey. Is that fair to say?
that's what it appears.
Now, you testified on direct examination that Melissa and Chris lived with your grandmother.
Yes,
If you can approximate, when did they live with your grandmother?
I don't remember the exact time.
Grandmother's house to a different location.
Yes,
Where did they move to?
They moved to Atlanta.
Do you know where in Atlanta?
I don't recall exactly. I think Brookline Street.
Now, Brookline Street, are those homes that were owned by your grandmother?
Yes,
Had you ever visited Melissa and Chris at the Brookline address?
I'm sure I have. Yes.
Do you think you spent more time with Melissa and Chris when they were living with your grandmother or when they were living at the Brookline house?
I think it was more with my grandmother. I can't remember.
Now, you talked about your kind of relationship with Melissa. Would you consider yourself friends?
Yes.
Did she speak to you about her life experiences?
I'm sure she did.
Did she talk to you about your brother?
I don't remember.
Did she ever discuss to you some of the difficulties she was having with your brother, excuse me?
No, I don't remember.
Did she ever talk to you about her and your brother arguing?
No, I don't remember.
You don't remember? Okay. What about them fighting? Did she ever talk to you about that?
No, I don't remember.
Did she ever talk to you about a July 1998 incident in which your brother pulled her hair and dragged her down the street?
No,
No, you don't remember.
no, I don't remember.
Do you know if she talked to you about the fact that your brother, was upset because she went to the male neighbor's house who was up the street?
No,
No, or you don't remember.
no, I never had the conversation.
Do you recall her ever telling you that she loved your brother, but she wanted to leave him?
No,
No, you don't remember. No, it didn't happen.
no, I don't remember.
Do you remember detectives back in around 2003 coming to meet with you regarding Melissa's disappearance?
Yes,
And do you remember it being a Detective Calhoun?
I don't remember who it was.
Do you remember talking to him about your friendship with Melissa?
I don't remember exactly. No,
I'm sorry, say that last part again.
no, I don't remember.
And I apologize. Do you remember talking on the phone with any detectives back in 2003?
No, I don't remember.
Did you tell that detective that Melissa wrote you a letter?
No, I've never said she's written me a letter.
So is it your testimony today that you never told a detective that Melissa wrote you a letter prior to her disappearance?
It is my testimony that she did not write me a letter.
And that you never told a detective?
I never told a detective that she wrote me a letter.
And that in the letter or either in a conversation, again, Melissa told you she loved your brother, but she was getting ready to leave him.
She's never told me that.
Do you remember Melissa telling you about a guy that she met at the Waffle House?
No,
And do you remember telling any of that to a detective over the phone in 2003?
I never said that. I don't. On the phone, no. I never.
Your mom, Kathy Wolfenbarger, she raised Melissa and Chris's children.
Yes,
Is it fair to say that your mother never talked about Melissa here?
can you rephrase that?
Sure. Is it fair to say that your mom did not speak about Melissa to her children after Melissa disappeared?
I don't know.
Is it fair to say that your brother did not speak about Melissa to their children after Melissa disappeared?
I don't remember. But they did take the children to Melissa's funeral, so I'm sure at some point they did talk to her, both of the children, because they were younger.
Would you agree with me that the funeral was in 2003?
I don't remember exactly when it was.
Let's speak about the funeral. At the funeral, did you know that Kathy and Chris didn't tell the children that it was an actual funeral?
Don't know.
Did you know that Chris nor Kathy actually wanted to go to the funeral?
I don't remember what their feelings were.
Let me ask, when the kids were younger, did you ever talk to the children about Melissa, your friend?
I don't remember exactly.
Do you remember ever telling the kids that Melissa was their mother and she disappeared?
I don't remember how and what was discussed.
Do you ever remember showing the kids pictures of Melissa?
I don't remember.
Now, in 1996, is it fair that Christina gave temporary guardianship to your mother?
Yes.
I'm sorry, was that a yes?
Yes.
Thank you. That's okay.
And, Your Honor, this time, the state is on the acts to admit States Exhibit 81 and 82, which are self-authenticating documents from the Henry County Probate Court regarding the guardianship of both Christina Wolfenbarger and Joseph Wolfenbarger.
Mr. McDermott,
No objection.
81 and 82 are admitted.
Thank you, Your Honor. Did you know, or do you know, if on July 23rd, 1998, Melissa dissolved their temporary guardianship?
I don't know.
Well, first, let me say Exhibit 81. And on State's Exhibit 81, am I showing you this document?
Yes,
And does this document read on a page that's clipped in the matter of Christina Wolfenbarger petition to terminate temporary guardianship of minor?
yes,
And does it say the petition of Melissa Wolfenbarger shows, one, petitioner is the natural as mother and father of the above named minor? Does it say that?
yes,
And then say that on 8/28/96, the court appointed Kathy Wolfenbarger as temporary guardian
yes,
of the above named petitioner and temporarily relinquished parental rights.
yes,
And then it says, wherefore petitioner prays that the court enter an order dissolving the temporary guardianship instant term.
yes,
Okay, and it has her signing, like Melissa's signature, or a signature, I guess.
yes,
Okay. And is the date of this July 23rd, 1998?
yes.
Did you know that that is 2 days after Melissa called the police on your brother?
No, I didn't know.
And you also see in State's Exhibit 82, the same document, petition to terminate temporary guardianship of a minor, and it's the same document for Joseph.
Yes,
And is it also on the 23rd of July, 1998?
yes,
And were you aware that about a week later, on July 29th, 1998, Melissa then asked for permanent guardianship or gave your mother permanent guardianship of the kids about 2 weeks later?
yeah, I don't know from the documents, yes, but
And let me ask you this, did you know that on the day that she gave permanent guardianship was the same day she dropped the temporary protective order that she took out of her?
I don't know.
How would you describe Melissa's demeanor?
I would say she was quiet.
Was she easily influenced by others?
I don't. Yes and no.
Why do you say yes and no?
I don't remember completely, but yes, I think she. I don't know how to put it into words.
Now, when was the last time you remember seeing Melissa?
I don't remember. I'm sorry.
Can you remember, was it at your family's home?
I don't remember.
Do you remember what she looked like the last time you saw her?
She looked like herself.
And when you say herself, describe for the jury what she looked like.
She just had a cute teddy bear round face with dark hair.
Dark hair, like down to her shoulders, about your length. When you say dark, like what's the length?
Ma'am, I don't remember exactly the length of her hair.
Okay. Was it longer, short?
A bit longer than mine.
Do you know if you saw her around the holidays?
I want to say I think that's maybe Thanksgiving, but I can't remember exactly.
Now, are you familiar with any of the podcasts that have come out regarding this case?
No.
Now, testified you all were close. When you didn't hear from her in a while, did you get concerned?
About the time that they moved to Atlanta, we were not close. I was a teenager. I was doing my own thing, and I had a boyfriend, so I was more focused on me.
And I get it, teenager. At some point in time, did you ever, when she stopped coming around, did you ever question where she?
I was told that they split up. I don't remember exactly when.
Did you ever question if she came by to see her children?
I don't remember. I don't remember.
Now, in the year of 2000, did you come to learn that there was a missing persons report regarding Melissa?
I don't remember exactly when I learned.
Do you remember speaking to police in the early 2000s about Melissa's disappearance?
Yes.
Did you ever speak to your brother about maybe talking to the police about Melissa being gone for a long time?
I don't remember what I discussed.
And is it fair that the only people that reported Melissa missing was her mother?
I'm not sure who reported her missing.
And is it fair to say that the only people who have been trying to get some justice for Melissa are her parents, her mother, and her sister?
I'm not sure who.
Court indulgence for one moment.
Sure. Thank you, Mr. McDermott. Anything else for this witness? Sure.
You remember reading a letter that was purportedly from Melissa to her mother just a few moments ago?
Yes.
And do you remember her mentioning any kind of time frame in that letter?
No.
Okay. Do you remember her saying that she was announcing to her mother in that letter that she was pregnant with Joey,
Yes.
or with who would become Joey, and that she was thinking of getting her tubes tied after that?
Yes.
Do you remember her reading in there that it said her next appointment for the doctor would be at the end of April?
Yes.
So that would mean that that letter would, the time frame for that letter would have had to have been in April of 1996.
Yes.
Do you remember it telling the letter communicating? Oh, never mind. I'll back off on that. You grew up, as you said, having a lot of interaction with Melissa because of your grandparents' house, right?
Yes.
And at some point, now, were you older or younger than Melissa?
Younger.
Okay. And how old would you have been in 1998?
I would have been.
Sorry to ask you your age in front of national TV, but sorry.
I think I would have been 15, 16,
Okay.
maybe.
And during that, as you said, that was the time you learned to drive
Yes.
and you started dating
Yes.
and you started developing your own life.
Yes.
And about that time is when Christopher and Melissa moved up to Atlanta.
Yes.
And at that point, did you stay close to Melissa?
No.
Okay. Did you talk to her much at all after that point?
No.
Okay. So after 1998, early 98, you kind of diverged into separate lives.
Yes.
Okay. So that would explain perhaps why you don't have very many memories of conversations with her, or
Objection, leading, Your Honor.
Sustained. You can rephrase.
so do you think that would explain why you don't have memories of many conversations with her?
Objection, leading.
It's argumentative. It's not really leading. Why don't you rephrase?
I'll just move on, Your Honor.
Sure.
Please find me the document you showed her in that second. Request her to dissolve it. Put it on the back.
They did that.
So, counsel for the state just showed you this document, didn't she?
Yes.
And it says a petition to terminate temporary guardianship of minor.
Yes.
And she asked you about the dates on that letter.
Yes.
And it says, wherefore petitioner prays that the court enter an order dissolving.
Yes.
Doesn't it? And state emphasized the word dissolving when she asked you that question, didn't she?
Yes.
But she didn't emphasize the word praise, did she? Because this is a petition to the court,
Yes.
correct? It's asking the court to do something, right?
Yes.
And did the court follow through with that something?
Yes.
Have you seen a document that says the court actually ordered
Oh,
the
no, I was
dissolution?
by that.
Okay.
No, I haven't seen it. No.
Correct. And would it surprise you to find that the court never followed through with that order
Would it surprise me? Yes.
to dissolve? Let me just rephrase it so I'm clear. That was a petition to dissolve the temporary guardianship.
Yes.
And would it surprise you to find out that the court did not grant that to Melissa? It did not dissolve Kathy's temporary.
Objection, leading.
Overruled.
Would it surprise you to find out that the court did not dissolve Kathy's guardianship based on that document?
Would it surprise me?
Yeah.
No.
Exactly. Are you aware of process for dissolving a temporary guardianship?
No.
It would surprise you to find out that the court requires it to be in the interest of the children?
I would hear so.
Backing up to the April 1996 date when the letter to Melissa's mom was purportedly written.
Are you familiar with this document?
I've seen it. Yes.
You've seen it? Can you tell us whose handwriting that is?
It appears to be Melissa's.
And whose name is on that document as a signature?
Melissa Wolfenbarger.
And does that appear to be an original document or a copy of the document?
Appears to be original.
Your Honor, if I could have a moment, please.
We need a defense sticker.
Okay, and you're on Exhibit 11, so.
Thank you. We cleared it off our desk for the court yesterday. And there you go. At this point, defense moves to admit defense 11.
And what is Defense 11?
It is a handwritten document from Melissa, previously authorized to be under 807.
There's not, I mean, we might have had that conversation. It might very well be coming into evidence, but I haven't heard a foundation or an identification of what that document is yet, so.
Could you tell us what that document is?
Are you asking me to read this one?
No,
Don't read it yet. Just
he's not. He's just asking you if you recognize that document, and if you do, what you recognize it to be.
I do recognize the document, and it is a letter to my mother
And a letter to your mother for what purpose?
stating her.
Hey, nope, sorry, don't read it. It's not in evidence. Who's it from?
It's from Melissa.
We had already covered that.
Okay, I apologize. I didn't hear that part.
Okay. So may I move it into evidence at this point?
Any objection?
No,
Defense 11 is admitted.
Now, would you please tell us the content of that letter?
It's Melissa telling my mother that she wants to give her temporary custody of Chrissy and the baby that she's carrying. And it's dated June 20th, 1996.
June 20th, 1996,
Yes,
and that would be roughly 2 months after April of 1996.
yes.
No further questions, Your Honor.
Thank you. Anything else, Ms. Witness? Ms. Hilton?
Just to, do you know Chris forced her to write that letter?
No, just like I don't know if she wrote that letter. I don't. So no, I don't believe Chris forced her to write that letter.
But you don't know.
I wasn't with them
No further.
24 hours.
Mr. McDermott, I'm sorry. Anything else, Ms. Witness?
Nothing further. Your Honor.
Okay, thank you, ma'am. You may step down.
Thank you.
The witness may be excused. Mr. McDermott?
Witness may be excused.
Mr. McDermott, defense may call its next witness. Sir,
May we
do
approach?
you need to approach, sir? Defense may call its next witness.
Defense called Kathy Wolfenbarger.
Come on up, ma'am, and if you would, Ms. Hilton, there are some exhibits up here. I think they're yours. Before you have a seat, if you'll face the deputy and raise your right hand, he'll swear you in.
You swear to affirm to the testimony that you'll have to give truth, the whole truth, and nothing but the truth. Yes. Please state and spell your name.
Kathy Wolfenbarger, CATHY WOLLENBARGER.
Good morning, Ms. Wolfenbarger.
Morning.
Suffice to say, you may be a little bit nervous.
Yes.
You don't like cameras,
No.
unlike some of us.
No.
Do you know the defendant?
I do.
How do you know him?
He's my son.
Okay, I want to ask you to lean forward, please, and speak closer to the microphone, and remember to talk kind of slowly.
Okay.
So, how do you know him?
He's my son.
Okay. And did you know Melissa Wolfenbarger?
Yes.
And how did you know Melissa Wolfenbarger?
His wife.
Okay. And did you spend a lot of time around Melissa Wolfenbarger?
Somewhat.
Somewhat. And describe your relationship at the time that you were around her somewhat.
Well, they mostly lived with my mom, and the kids was there, and I would go and visit up there
How far away did you live from your mom?
from Locust Grove to Stockbridge.
Okay. So how often would you go up there?
Just maybe I don't know, just every other day or once a week or something.
I want to show you a document that's already been admitted into evidence. Are you familiar with that document?
Yes.
And can you describe what that document is?
Melissa giving me temporary custody of the children.
And when she gave that to you, did she give you any reason why she was choosing you as opposed to someone else?
She does not want them down her parents' house.
And at some point later, did you make that temporary custody permanent?
She did.
And you remember what year that was?
I don't know.
And when she had you do that, did you go down to the courthouse, or how did that work out? How did you get the message from her that she wanted you to do that?
Called me on the phone.
From where did she call you from?
I was at my mother's house, my parents' house.
And where was she calling from?
I assumed the court place. I
At
don't
the
know.
courthouse?
Mhm.
Do you remember when Christopher and Melissa moved to Atlanta? Just generally speaking.
Just, I'm not sure.
Do you remember that they moved to Atlanta?
When they moved to Atlanta?
That they moved to Atlanta.
Yes, they did move to Atlanta.
Okay. And do you remember what street they moved on to?
Brookline.
Okay. And who owned the house they lived in?
My parents.
Your parents, both William Autry
In
and
Virginia.
Virginia.
Yes.
And did they own any other houses in that area?
Two. There was three altogether.
3 altogether.
Mhm.
And did a Mr. Holyfield ever own the house that Christopher lived in?
No, he didn't.
To your knowledge, did he own any of the houses?
He
that
did
your
not.
parents- Okay.
As my knowledge, he didn't.
Do you know who Mr. Holyfield was?
I'm not sure. I've heard of the name, but I'm not really sure who he was.
I'm not talking about the boxer.
Oh, no. Okay. No.
All right. Do you remember during the time that Melissa went missing? Did you ever talk to the police? Did the police ever come to talk to you about Melissa being missing?
I can't recall, but I don't know. I can't remember if they did. I don't know.
Is it possible? that
It's
they did?
possibly they did.
Okay. And somewhere around the time frame of 2001, early 2000s, do you remember ever taking down Melissa's pictures from your home?
They, well, I'm always changing my walls and my pictures and stuff, so probably did.
Is it possible? That
Possible, yes.
Okay. Do you remember a time that certain pictures of Melissa were stolen from your house?
Yes.
Okay. Describe that a little bit for me.
When we had moved to McDonough, I had photo albums in my garage, and there was some photo albums or pictures got gone out of the photo albums, and there was 2 lanterns that I had out there that was gone.
2 lanterns.
Lanterns I had on my front porch, I had put in the garage, and they had that gone.
And why had you moved the lanterns to the garage?
Because we was working on the front porch painting it, and we was putting the stuff in the garage.
Okay. So you were doing some renovation work
Yes.
and you put some stuff in storage in the garage?
Yes.
Okay. No further questions at this time, Your Honor.
Ms. Hilton, any questions for this witness?
Yes, sir. Good afternoon.
Yes, ma'am.
Now, you just spoke on direct examination regarding the homes your parents owned on Brookline. The homes your parents owned, I touched the mic. The home your parents owned on Brookline Street in Atlanta.
Yes.
You said it was 3 homes,
There was duplexes.
duplexes.
Yeah.
But were there 3 duplexes that they owned?
Yes.
And is one of the addresses 823 Brookline?
Yes.
Was another address 824 Brookline?
Yes.
And what was the third address?
I'm not sure. I'm not sure.
Now, these homes, are they the homes that you grew up in?
The 823 one was.
823 you grew up in. Did you have other family members in 824 in the other?
My uncle.
About how old were you when you moved from Brookline?
Was I?
Yeah, because you said you grew up in 823, right?
Yes.
Okay.
Probably about 17 or 18. I mean,
When you moved out of Brookline, did your parents still live there?
yes.
And did your parents eventually move from Brookline?
Yes.
Roughly what years do you think your parents may move from Brookline?
I'm not sure. I don't know.
70s, 80s, 90s?
Probably about 2000. I don't know.
Oh, 2000.
I guess. I'm not sure.
Once you moved out of the Brookline house, did you ever live back on Brookline?
No.
Once you moved out of Brookline, how often did you go back to Atlanta?
No, I don't know.
I apologize, ma'am. I've heard everything you've said so far, but if you'll just make sure and speak up a little bit into that microphone. Thank you.
I'm sorry.
Would you ever go to Brookline to check on the homes on Brookline?
To check on, no, why would I? No.
No.
Mm.
At some point, did your brother Rick live in one of the houses on Brookline?
Yes.
Which house did he live in? Do you remember?
823.
Did you ever visit your brother on Brookline?
Yes.
Did your brother live at 823 Brookline in the late 80s, early 90s?
I'm sure he did. I'm not sure. I guess. I mean,
Would Chris ever visit your brother Rick at the 823 Brookline house?
I don't know because I mean, I guess, I don't know.
Now, Mr. McDermott asked you about Mr. Holyfield.
Mhm.
Is
Yeah,
that
I'm
right?
sorry, yes.
It's okay. Do you know Mr. Holyfield's first name?
I have no idea.
Now, you said that Mr. Holyfield never owned any of your homes. Do you know Mr. Holyfield managed any of the homes?
No,
How do you know Mr. Holyfield?
I don't.
How do you know that name?
Because it was through the, I don't know him.
Did he have some connection to your parents' homes on Brookline?
I don't know who. I've heard the name, but I don't know.
She testified on cross that she didn't know who he was. So this is pretty much asked and answered. What's the point?
Overruled. Go ahead.
You said you know the name.
Mm.
Why do you know that name?
For the houses, I guess, I don't know. I don't know.
Now, you said that Chris and Melissa lived at your parents' house at some point.
Yes,
If Chrissy was born in August of 1995, is that fair? Chrissy was born in August of 1995.
yes.
When did they live with your parents?
The years I'm terrible with the years. Oh, probably probably a year old or so, or maybe I don't know before. But probably about a year old or so, or before. I don't know. But
Were they living with your parents before Chrissy was born?
before, I don't think so. I think they had no, or I don't know.
So is it fair to say they didn't live with your parents until after Chrissy was born?
Yes,
And so that's sometimes after 1995.
yes,
And they lived with your mother for about 2 years, 2 or 3 years, and moved to Brookline in 1998.
sounds like it. Yes,
And they moved into 824 Brookline.
yes.
Did you ever visit them at 824 Brookline?
I guess I'm not sure. I don't think so.
You don't think so?
I don't know. I don't know.
Do you know if they were paying rent to your mother when they were staying at 824 Brookline?
I'm pretty sure there was.
Now, in 1998, at least the early part of 1998, you had temporary guardianship of Chrissy and Joey,
Yes.
correct? Did you ever take the kids to go visit their parents on Brookline?
They would come and visit them. Yeah, they would come. Yeah.
When you say they would come, will you bring the kids to Brookline, or are you saying they mean Melissa and Chrissy would come to you?
Chris Willis would come in there.
They would come to visit you?
They would, yes, they would come, yes.
Did you ever visit Christopher at his job, at any jobs he ever had?
No,
Do you know where your son was working back in 1998?
I'm not sure, but they said the last place is what, is it, I don't know.
Have you ever been to the glass?
No, I don't even know where, no.
You said you don't even know where it is.
No.
Isn't it true that Melissa wanted to dissolve your temporary guardianship in 1998?
No,
I'm sorry?
no.
She did not want to dissolve it.
I'm sorry. Can you reread what you said? I mean,
Did Melissa want to dissolve the temporary guardianship?
dissolve it? I don't,
Did she not want you to have her kids anymore for a short period of time?
no, no.
Are you aware about an incident in July of 1998 in which Melissa took out a TPO on your son, a temporary protective order on your son?
I did not.
Did you ever go to court with your son to answer to a temporary protective order?
I didn't know anything about it.
When Chrissy and Joey were younger, isn't it true you wanted them to call you mother or mom?
No, they just called me mom, but they knew I was their grandmother.
Did you ever tell Melissa, Chrissy or Joey about Melissa after she disappeared?
I told them we would go look for her, but we didn't know where to go look.
When you say you would go look for her, what do you mean?
I mean, she was gone. We just, we would look. I mean,
Where'd you go
wherever-
look for
I
her?
don't have no idea. I mean, if somebody would go, we'd just go look for her.
Where'd you go look for her?
We didn't because we didn't know where to go.
Oh, so you didn't go look for her?
No.
Did you ever tell them about their mother?
I told her that she had left and that we would go look for her. If we could, that's about it.
Okay, so you told them that she had left and that you would go look for her,
Yeah.
but you never went to go look for her?
We didn't know where she was at
So why did you tell the kids that you were gonna go look for her?
because we would go look for her if we knew where she was at. I mean, but
So is that what you told the kids? If we knew where she was, we were gonna look for her?
Yeah, I mean, yeah, we didn't know where she was at when she left.
Did you ever tell the children that Melissa was their mother?
Yes. And Chris was the father.
Now, you talked about, I guess, Melissa's pictures being stolen. Is that what you told Mr. McDermott?
Yes, there was pictures. Yes.
Tell me about that. So was just Melissa's pictures stolen or all the pictures were stolen?
There was pictures in my photo albums was gone, and some of them was the pictures of Melissa. Yes.
So was it only the pictures of Melissa that were stolen?
Pictures of her and Chrissy and just of the kids, you know, and her.
Did the children ever ask you, strike that, let me ask you a better question. Do you recall Chrissy and Joey finding pictures and asking you about Melissa in those pictures?
No.
Do you recall not telling them who Melissa was?
No.
Do you recall once they began questioning you about Melissa, taking the pictures and putting them in a shed?
No.
Is there any reason anyone would have to make that up?
I have no idea.
Would Chris ever tell his children about their mother?
I'm pretty sure he did.
Did you ever see Chris do it?
No, he would have them.
How often would he have the kids?
He would have them a lot. I mean, he would come up and play with them and take them places, and we all went to Six Flags. And
when was the last time you remember seeing Melissa?
I guess at the courthouse when we done the papers. I don't know.
I apologize, ma'am. I just need you to speak a little more loudly and clearly into that microphone. Thank you.
I guess when she did the paperwork at the courthouse. I mean, I don't remember when.
Now, is this in 1998?
98, I believe so.
Now, do you recall in 1998 when you got full guardianship or permanent guardianship of the children, do you remember Norma Patton bringing the children to you?
Bringing them to me?
Yes, like giving you the children.
No, I don't remember her bringing them to me. No.
Do you remember Norma Patton ever giving you the kids at any point in time?
I remember they was at their house one time, and they brought them back, and they had a head full of lice, and they had Joey had diaper rash, and me and Melissa went down to Walmart and got some stuff and done all their heads with. I mean, that's for us the only time I remember this.
So you never remember picking her up, picking the kids up?
Kids up?
You don't remember that? Did you ever see Melissa around the holidays in 1998?
We had Christmas at my mom's house.
Okay. Do you remember that being in December of 1998 when you had Christmas at your mom's house?
Yeah, I guess, yeah.
Okay. Was Melissa present at that Christmas at your mom's house?
I guess. I mean, I guess she was.
Do you remember seeing her?
Yeah, I guess we're always there. I mean,
when you last saw Melissa, what do you remember? What did she look like?
Long brown hair, just an average girl. I mean, just
long brown hair, about your length?
Probably.
And this is maybe around December of 1998 at that Christmas at your mom's house.
Yes.
Now, after Christmas of 1998, when you didn't see her anymore, did you have any concern about her whereabouts?
Yes.
Did you call the police or anyone to see that she was missing or to report that she was missing?
No.
To your knowledge, did your son call to tell anyone that his wife is missing?
I'm pretty sure he did. I mean, I don't know.
You don't know. In 2000, do you recall a detective from the Henry County Police Department coming to speak to you about Melissa's disappearance?
In 2000?
Yes.
I don't remember.
And do you remember being reluctant about giving him information about Chris?
I don't remember that. No.
Do you recall this detective wanting to kind of make contact with Chris so he can talk to Chris about his wife's disappearance?
I have no recall about any of that. No.
And I guess it's fair to say that since Melissa went missing, you didn't really go look for her, right?
No, I didn't know where she was at.
To your knowledge, your son didn't go looking for her, right?
I'm pretty sure he did. I mean, I don't know.
And it's safe to say you love your son, right?
Yes.
And as a mother, you're a protector of your son, right?
Yes.
Court's indictment.
Sure.
I figured about two,
And
maybe,
just
or one. So.
a couple more questions. In that picture, is Melissa wearing long sleeves and long pants?
No, she's in like a little, short little, is it like a culottes thing, like a,
And has she got any bruises on her arms or legs? or
no,
face?
not at all. And she's smiling and she's laughing, happy.
I don't have anything further.
Ms. Hilton, any additional questions for this witness? And when y'all are done, if you'll sort of just collect the photographs on that front ledge. Thank you all.
First, ask you this. In 2023, around December of 2023, did members of the Fulton County District Attorney's Office and Investigator Shepard come to your home or your daughter's home to speak with you?
23, I'm not sure. I mean, I don't know.
Do you
Did
remember seeing this man before?
Oh,
Do you remember him? Seeing him?
I think I've seen him before. I mean, yes.
Was that at your home?
At
your
my
daughter's
home? I don't think it was at my home. I don't remember. I don't know. Just,
Do you remember anyone in the 2020s coming to talk to you about Melissa's disappearance?
yeah, they came to my daughter's house. Was it last year or something like that?
And that was before Chris got arrested. Is that fair to say?
Before, yes. I think it was in January.
Now, we talked about these pictures. Looks like graduations, fishing trips, birthdays, kindergarten graduations. And these are all events that Melissa didn't have the pleasure of enjoying. Is that correct?
She was in some of the pictures,
She's in one of the pictures, right?
I guess. I mean, yeah.
Is it just that last one where they asked you about what clothes she was wearing?
Oh, thank you. Thank you.
This is the only picture that has Melissa, right?
Sorry, is that a yes, ma'am?
Oh, yes.
Thank you.
And that's been this picture in 1995 or 6 is Kristen Stroll.
There was one at that went to there was one that we stayed at Six Flags.
But in this picture, this is before 1998, correct?
I guess, yes.
Okay. So this is before Melissa ever called the police on Chris for hitting her, correct?
I don't know.
And some of these pictures are after 1999. Is that fair to say?
Yeah.
After Melissa's body and head was found on Avon Street?
I guess. I mean,
After her torso, which has never been found?
I guess. I mean, I don't know. I mean, I don't know.
Melissa didn't have the opportunity to participate in her children's lives because she was dead, correct?
I guess. I mean, I don't know what happened to her. I mean,
Sustained.
It's argumentative.
I already said sustained, but thank you.
Stop that.
I have no further questions. Your Honor.
Thank you. Anything else, Mr. McDermott?
Nothing for this witness, Your Honor.
Okay, thank you. You may step down, ma'am. And the witness may be excused. Mr. McDermott? Okay, the witness is excused. You would just leave that there, ma'am. Thank you. So it is my intention, it's nearing on 12:45, and so I was going to go ahead and break for lunch. And so, ladies and gentlemen, it is about 12:40. I'm going to have you back in here around 1:40 to resume the afternoon. So we're going to break for 1 hour for lunch. Enjoy your lunch.
Wow, what do you all think? Want to tell, but she knows something, I fear. Just my opinion. Okay, let's teleport through lunch.
Okay, you may be seated. Mr. McDermott, I need a at some point to have a conversation with Mr. Wolfenbarger in terms of his intentions regarding testifying? Is that a conversation that you've already had with Mr. Wolfenbarger, and that's a decision that's been made by Mr. Wolfenbarger to your satisfaction?
Not quite.
Not quite.
I want to talk about that.
Okay, so talk about it over lunch, and then perhaps we'll revisit it when we return from lunch before the jury comes back in?
Yes.
Okay. Anything else the parties want the court to take up before we adjourn for lunch?
Nothing to say, Ron.
Nothing for the defense.
Okay, thank you. We are in recess until, for that reason, if you guys could come back a little closer to 1:30 instead of 1:40.
Your Honor, off the record.
Yes, sir.
I'll just be frank.
And so have you had a chance to have those conversations, Mr. McDermott?
Yes, ma'am.
Okay. So is now acceptable to you for me to inquire with Mr. Wolfenbarger?
Yes.
Okay. Mr. Wolfenbarger, so I'll tell you, like I tell witnesses, I'm fixing to ask you a series of questions, and when you answer, I'm going to need you to answer out loud so that the court reporter can take down your response. Do you understand, sir? Okay. So, Mr. Wolfenbarger, do you understand that you have a right to testify in this trial, and that if you want to testify, that nobody can prevent you from testifying? Okay. And do you understand that nobody can make you testify? That is, you have a right to not testify if you don't want to. Okay. And do you understand, sir, that you, not your lawyers, are the person who makes the decision whether you will testify or not testify? And do you also understand, sir, that if you do not testify, then upon request by you or your counsel, that I will instruct the jury that your decision not to testify cannot be used against you in their deliberations? Okay. So you do understand that? Okay. And do you understand that if you choose to testify, you won't just get asked questions by your own lawyers, you will also be subject to cross-examination by the state's lawyers? You understand that, sir? Okay. Now, I don't want to know what you've discussed with your attorneys, but have you had a chance to discuss with your attorney the decision whether you will testify or not testify? Do you need any more time to talk to your lawyers about that decision? Okay. Having had an opportunity to talk with your attorneys about that decision, do you wish to testify in this case, or do you not wish to testify? You do not wish to testify. Is that correct? Okay. So thank you, Mr. Wolfenbarger. Based on your responses to my questions and your representations regarding having had ample time to discuss that issue with your attorneys, I find that Mr. Wolfenbarger has made a decision to not testify, and that decision has been made with an understanding of his rights, and that decision is knowing, voluntary, and intelligent. The second issue I wanted to take up with y'all is, it might not matter at this late hour, but my understanding is that the Sheriff's Department has now acknowledged that warrant and said they are taking care of it. So I don't know what that means, but it is what it is.
That's what the deputy told me as well, and it's unclear how we can kind of monitor it, but I know in the past when I tried to call the warrant division, they rarely give me much information, but I've taken their word for it, they're working on it, and we'll either stay in touch with you or maybe the DA's office, and I can try calling the warrant division. I just know they're usually very reluctant to get information on the phone, so.
Okay, thank you. Now, the other thing I wanted to take up, I don't know how long it might take and where we are in terms of how much more time we might need with the jury today before we would be ready to for the case to be done. But we do still need to revisit the matter of the motions that the defense wanted on the record in terms of any motions at the close of the state's case. As we put on the record earlier, in an effort to be efficient with the jury, we went ahead and reserved your opportunity to raise those objections or those motions after we went ahead and proceeded with the state resting in front of the jury and then y'all going forward with some witnesses that you had.
Yes.
Okay.
At this time, in light of the state's having rested its case, we would move the court for a directed verdict of not guilty on both counts. On malice murder, the state has not given any evidence of a cause of death. They have not shown any evidence that Christopher caused Melissa's death. They've not shown any evidence that she died unlawfully. On felony murder, they've not given any evidence that an aggravated assault occurred. Evidence that an assault occurred. They've certainly not given any evidence that it occurred with an object that could result in serious bodily injury. And they've certainly not also given any evidence that an aggravated assault occurred that caused her death. And they've not proved the cause of death. In neither case have they proved an intent to carry out either an aggravated assault or a murder with malice aforethought. In this case, Your Honor, is the evidence of guilt is only circumstantial, and the court must rule out every reasonable hypothesis that would support his innocence. They have not ruled out the fact that other people, including the victim's parents, including the victim's uncle, Martin Eric Jackson, including any number of random people in the area, could have carried this out. There are a number of reasonable hypotheses, and we've given evidence for some of them. And the court is authorized to apply that standard in granting a directed verdict. Just a second, Your Honor, please.
Sure.
The state has given some evidence from which, from what we've talked about with prior difficulties regarding the incidents of alleged domestic abuse that occurred in July of '98 and at some undetermined time before that. But when you're considering what a reasonable juror, well, I think your jury instructions covered as well. As far as what a reasonable juror would be allowed to consider as toward the elements of the crime, they cannot consider or infer character may not infer from those things that he had the good character to commit other such crimes or wrongs later. In other words, they can't use that as propensity evidence. So they can't say, well, he did this, he may have hit her on one other occasion, so he must have done it later, and therefore that fulfills one of the elements of the crime. They can't do that, and this court can't consider that. And as far as prior difficulties are concerned, the finder of fact is only allowed to use that to consider a state of feeling between the parties. So I would say there's abundant lack of evidence in this case of intent and of the elements of the crime. So we would request the court grant directed verdict at this time.
Thank you, Mr. McDermott. Who will I hear from for the state?
Hey, Judge.
Mr. Fassett,
Yes.
your response?
Your Honor, would cite two cases. There's a, where my computer goes. Your Honor, would cite two cases as authority for the court to base this decision on. The first case is Odom versus Hughes. That is a Georgia Supreme Court case, 293 Georgia 447, 2013. Second case is Miller versus Lynch, 351 Georgia Pellet, 361, 2019 case. It ultimately speaks to the decision before the court when there's conflict and when there is no conflict in the evidence that's been presented by the state. Miller states the trial court may direct a verdict only if there is no conflict in the evidence as to any material issue, and the evidence introduced with all reasonable deductions therefrom shall demand a particular verdict. Where any evidence, even slight evidence, supports the opposing party's case, the directed verdict is improper. So first, the state is not required to prove evidence of motive, but the jury is authorized to consider evidence of motive. In this case, I would cite evidence of three different potential motives for this defendant to murder Melissa Waffenbarger. First was the pending state court case from the July 1998 incident. There was a battery, and even though Melissa wrote an affidavit saying that she no longer wanted to pursue the TPO, we know from the March 29th, 1999 date that criminal case was still pending. I think the fact that that case was still pending and that Melissa was murdered and was unavailable to attend, her head being found a month after that case was dismissed when they couldn't locate her, I think the fact that there was a pending case that jury could consider. I think that the fact that this defendant was aware that Melissa Waffenbarger was seeing an individual he referred to as Mike, we heard testimony from and confirmed, corroborated that. The fact that she was having an affair is another form of motive, possible motive for this defendant to murder Melissa Waffenbarger. And we also know from Melissa's mother, the letters, and this defendant's own mouth that Melissa planned on leaving this defendant. All three of those independent, separate, possible motives for this jury to consider as reasons why this defendant would want to have Melissa Waffenbarger murdered. There are prior difficulties. And those prior difficulties further corroborate the battery that occurred on July 1998. There are three instances of the prior difficulties. The first in the beginning of the year, I believe it was February or March of 1998, where Tina Patton describes seeing marks around the neck of Melissa Waffenbarger. As does the officer, Marlon Sutton, describes the events that took place on July of 1998 when he, according to his report, observed bruises and abrasions on the person, Melissa Waffenbarger. And then we have Thomas Dixon at the end of December 1998. He's relaying information about the continual abuse that Melissa endured during that period, during that year. And also, again, how she planned on leaving him. I would say that from the testimony of the medical examiner's office, the medical examiner, Dr. Terry in particular, her testimony was that she does not, in her expert opinion, believe that Melissa Waffenbarger died of natural causes. That is from the circumstances of the facts that she reviewed, the fact that there were tool marks on the person, the bones of Melissa Waffenbarger, on the neck, on the limbs, on the femur. The fact that the bags appeared to be situated to where she was, in her opinion, murdered at a different location, that those bags were placed there very recently to the time that they were located. Because of the rip in the bag, she isn't able to tell the time of death. You know that the head had not been outside of that bag for more than a day because there were no maggots, there were no insect activity. The doctor couldn't say whether or not the remains had been refrigerated and dropped off. That was a possibility. She also couldn't say, she couldn't say whether or not Melissa had been strangled because the parts of her neck were missing for her to make that determination. She couldn't say if she had been strangled. She couldn't say if she had been choked, stabbed, shot, or a number of other different manners of death were just not available for that determination because of what was missing. And I don't believe that the defendant should be able to benefit from how well he was able to dispose of her body. The statement from Dr. Terry is that the circumstances lead her to no other conclusion that it's highly likely that she died of homicidal violence. And I think that that in and of itself are facts sufficient enough that the jury should decide this case. I would ask that the court deny the defense motion.
So I agree with you absolutely regarding the murder charge, that there is evidence from which there's evidence in the record that would create issues for a jury regarding the fact that homicide occurred and the fact that Mr. Wolfenbarger may or may not have caused that homicide, which are issues for the jury. So I'm going to deny your motion on the count one for murder. I think for largely the same reasons, I should refrain from granting a directed verdict on the felony murder. But I mean, candidly, I do have some concerns about the fact that even if there are clearly facts, the circumstances of her being found, right, that would support an inference, right, a reasonable inference if the jury decides to make that inference that the cause of her death was homicidal in nature. There's not any facts from which we can determine that any sort of weapon was used against her in any offensive manner. So how do I reconcile that?
Well, so it is not required for it to be a weapon. A weapon per se weapon. So it's not required that the weapon be per se like a gun.
guns per se weapon is by statute, but any object that has a possibility of causing serious violent injury.
Right, but there's no evidence of that. That's my point. I can infer that she was killed by homicide because of, for example, a jury could infer that from the circumstances of how she was found and how her body was dismembered and disposed of. But can you also rationally infer that she must have been assaulted with an object which, when used in the manner in which it was used, is likely to result in serious physical injury or death?
Yes, you can.
Okay.
And the reason why is because if she did not die of natural causes, there is the inference that there is an intentional act by the part of this defendant to cause her death, whether that is poisoning. That would be a substance that would cause serious violent injury. The aggravated assault could be the poison itself. If it was his hands around her neck and strangling her, the hands would be an object. We typically charge fists, feet, knees, elbows. All of those objects could be offensive weapons depending on how they're used. And it could be something that is man-made, like a gun, like a knife, like a belt or rope. The indictment is charged is because it is because there aren't parts of her that would allow for a determination, like the torso, for instance, like the neck structure. We cannot, with any degree of medical certainty, narrow down the limitless possibilities of objects that could have been used to kill Melissa Waffenbarger. That's why, because of the circumstances of this case, dictate that the indictment be charged in a way to allow the jury to consider all of those possibilities. And so the court is going to instruct the jury.
Well, I mean, not necessarily. The DA could have elected to just charge murder because either you can or can't prove murder. They didn't have to charge felony murder. I mean, you said we had to allege it the way we did. That's if you chose to allege felony murder, right?
Right, having made that decision to charge felony murder, I think that the intent was to give the jury the ability to consider all the reasonable possibilities of objects that could have been used to commit this serious violent injury on the person of Melissa Waffenbarger. And I'm saying it's serious violent injury because it wasn't a natural death. There's no sense of circumstances create really the only reasonable inference is that this was a homicide. And so I think if
Again, don't disagree with you that maybe the inference is that it was a homicide. The question is there a reasonable inference that it was an aggravated assault that caused a homicide
and I guess what I'm saying is it is impossible for her to have been murdered with an intentional act.
without having also had an aggravated assault?
That is correct. That's correct. I don't see a scenario that's possible. That's why I've mentioned poison. Any object that would cause the death of Melissa Waffenbarger with an intentional act would fit a category of an offensive weapon.
Okay. Thank you. Mr. McDermott, your response, sir?
What I hear the state saying is we can't eliminate every other reasonable possibility. And in the circumstantial only case, that's the standard by which it gets judged. It has to be. You're about to read jury instructions to the jury that says if the state has not excluded every other reasonable hypothesis.
Right, but that's a decision for the jury, not for me
No,
necessarily.
not only. There are cases that say that standard can be used during a directed verdict. Wood v. State, more recent one, I don't know the number here, if you want to look at it. Stack-Thorpe v. State, that was a 2004 case. It was a negative case, but they upheld the same standard. You may use that on a directed verdict. And what I hear the state arguing is they're basically confessing to you, we have not eliminated every reasonable hypothesis. We can't tell you if it was poisoning, which, by the way, is not aggravated assault by a deadly weapon. It's a whole different category that they didn't charge. And I was going to say, and the same with strangulation. It is a separate statute under the aggravated assault statute. They didn't charge that. They charged specifically offensive weapon.
Setting aside the somewhat nebulous understanding that we all have because of the circumstances of how Melissa's body was found, am I wrong that the state is allowed to prove facts that would demonstrate in any way that it might have occurred? I mean, I understand your position is they haven't offered any facts about how it might have occurred, but there are different ways that someone can be assaulted in an aggravated manner, and aren't they allowed to offer facts that would prove any way that might constitute that under the statute?
Well, I mean, they can offer whatever they want as long as the court allows it. But as far as proving what they charged in the indictment, they have to prove an offensive weapon.
Right.
Okay. It can't be by strangulation, it can't be by poisoning, and they've not eliminated by the way that she died of a drug overdose at somebody's house and they panicked and tried to hide the body. There's a lot of possibilities they haven't tried to eliminate. And that's what I'm trying to say. This doesn't need to go before the jury. They don't have proof that an aggravated assault happened. They don't have proof of a deadly weapon. And they don't get to say, well, just let us have a smorgasbord before the jury. It's supposed to work in the opposite direction. If you charge something, you're supposed to be bound by that.
Okay. What, Mr. McDermott, you mentioned the Stack case. Can you give me that citation?
It's Stack-Thorpe, citation 270 Georgia Ave 96.
Okay.
The other case is Wood v. State. It's a little older. 156 Georgia Ave 810.
Thank you. As I've said, I'm going to deny the motion for directed verdict on the count 1 for murder. I'm going to look at the case line, and I'm not going to rule right now on the DV on the felony murder count, which is count 2 of the indictment. Do we have other witnesses that we'll hear from the defense?
I have one other witness here.
Okay.
I was trying to get in touch with another one who's just not going to be available, except maybe by Zoom. Did we discuss that? And then the one we're trying to arrest.
Okay, so if I tell you that we're ready to resume for the afternoon and you have your one witness when they're done, and you don't have another witness, are you ready to arrest? What's going to happen then, sir?
I still want that other witness here. I'm going to ask for a continuance of this if she's not here.
Okay. Obviously, does the state anticipate that there will be some rebuttal just from a timing perspective?
Yes, Your Honor.
Okay, like how much? Like whole day's worth, or?
No, I would say at most an hour, hour and a half.
So we're still thinking, other than perhaps this witness and the request for a continuance to find that witness or deliver that witness here, we're still thinking that today, we can get the evidence closed in this case. Is that still reasonable to you, subject to this witness?
Well, I mean, assuming my witness, yeah, subject to the availability of that witness.
Mhm.
If she were here, I would probably need an hour, maybe 45 minutes with her.
Okay. So anything else we need to take up before we bring the jury back in?
Nothing on the state trial.
Nothing from us currently.
We're ready for the jury. Mr. McDermott, the defense may call its next witness.
Barger.
The defense calls.
I'm sorry.
That's okay. Come on up, sir, and when you reach the witness stand, if you'll do me a favor before you sit down, turn around and face the deputy and raise your right hand. He'll swear you in.
You swear to warrant the testimony that you're about to give. Your Honor, I think I need to get Ms. German to admit me to the Zoom.
Ms. German, or Mr. Freehoff, or Ms. Johnson, can somebody admit Mr. McDermott to the Zoom?
I think I'm with the state and you think I'm the defendant.
Yes, exactly.
Joseph Wolfenbarger. That's JOSEPH WOLFENBARGER.
And if you would, while you're testifying, if you'll just try to lean forward into that microphone to make sure that we can hear you, okay, sir? Thank you. Go ahead, Mr. McDermott.
Mr. Joey, do you know the defendant?
Yes,
How do you know him?
that's my father.
And do you know Melissa Wolfenbarger?
I've no ever.
And do you know Kathy Wolfenbarger?
Yes,
And how do you know her?
that's my grandmother.
And do you live with her?
Yes,
What do you do for a living?
mechanic for the most part.
Did you grow up with Kathy Wolfenbarger in her household?
Yes,
Do you remember at any time growing up, say around the early 2000s, that she took all the pictures of Melissa Wolfenbarger down from your house?
I don't really recall ever seeing pictures of her like in the house.
Do you remember at some point in your life being told what happened to your mother?
Yes, more so at a young age.
And what were you told at a young age?
I mean, I would say I was at least about 4, 5, maybe.
And what were you told about her?
Your Honor,
It was-
I'm going to object to that. That would be hearsay.
You know, don't know exactly.
Sorry, I apologize, sir. When there's an objection, I have to just wait and not answer the question. Can you come here for a second, please? Mr. Wilson, the objections are ruled. Mr. McDermott, please go ahead.
I'm going to attempt to go back in, if I may.
Sure.
It might help to have the current day, right?
That would help. There's a new one every day.
Thursday, August 21st.
Yes, sir.
All right, we'll see if it works. Okay, I'll repeat the question. Do you remember what you were told happened?
That somebody had killed her, and that it's only so much you can tell a small child, but it was more so that it was done in a very horrific way.
Did you at some point move in with your father?
I mean, yes,
And how old were you when that happened?
it was after high school. It was.
Okay.
Yeah, I can't recall the exact dates, but
Do you remember where you lived at the time?
yeah, same place he was found.
Was it
In Griffin.
in Griffin? Okay. And did anyone else live with you at the time?
Yes,
And who were they?
my little brother, Alias, and it was mainly just us three.
Did your sister live with you at any point?
No, that was before.
Did she come visit you at any point?
At what time are you referring?
This is afterwards.
Like,
Okay, let me try a different way. Do you remember at some point the defendant making a comment while watching a TV show that he knew how to dispose of a body by burying it under concrete or something to that effect?
it wasn't necessarily from a TV show. It was more so we were discussing about how Carl had gotten away with other murders, and we were talking about different scenarios. And my sister had walked in later on, kind of caught half of the conversation, and kind of been standoffish about the conversation.
Okay, so a couple questions just to clarify. The context of the discussion was Carl Patton's murder.
Right.
Okay, and at some point, Chrissy walked into the room and overheard the conversation.
Yes.
Your Honor, I'd like to share screen, please.
Hey, are you in?
I am in now. And what I want to share, as previously discussed, self-authenticating document is a nationally reported news article. I emailed it to you as you were advising.
Y'all can-
All right.
Center. Thank you.
All right, jury.
You can sit down. Yes. You just sit right there. Outside for just a moment, please. Thank you. But don't wander far, okay? Who that conversation was? We're talking about the one in 2001?
No, 2021.
2021, thank you. And that was with Calhoun?
Shepherd.
Shepherd.
And
Okay.
Layton.
Okay.
And it's the one where they, basically, they get into this in passing. He mentions that their body was in bags. Speaking of something that happened much earlier, right? But they're like, we never told you they were bags.
Okay. Mr. Wilson?
Your Honor, I can't see how this is the proper witness to publish an article. I think that what he said himself is that he's offering it for the effect that it had upon Christopher Wolfenberger. Not Joey Wolfenberger, but Christopher Wolf. I think that needs to come from the defendant, Your Honor. This is using hearsay, and to say it's not for the truth of the matter asserted, unless he has personal knowledge of the facts behind it, it absolutely is offered for the truth of the matter asserted, not what effect it had on the defendant when you're asking another person to testify as to the effect that it had upon the defendant
Okay, well,
by showing the article.
I wouldn't let him testify about what effect it had on his father.
Okay.
Go ahead.
Well, Your Honor, showing that article is tantamount to putting it into evidence. I think he can ask if he knows. He can ask what his personal knowledge is of articles on but to put that article on there and that somehow give it a self-authenticating extra level of authenticity, so to speak, that's improper, Your Honor. Because that's what they're doing. They're bolstering. They're trying to bolster testimony by using a news article, which is not really how it should be done.
I also, so at the time I did review the article, and I looked at some case law, and the concern I have here is that there are ways to ask Joseph Wolfenbarger, were you aware that your mother had been found? Did you become aware that your mother had been found in bags sometime before 2021 or whatever? There are ways to establish that. There are even ways to establish that news articles that were widely available existed. But the only purpose, in fact, I mean, the only purpose to offer a news story like this, the only reason that it's self-authenticating is because the idea is that the facts in there are true and can be relied upon because they are in widely available, reputable publication. And what I need to pull up the case law that I was looking at because it was like a week and a half ago. I was looking at it like a week and a half ago, but ultimately my concern is that this is going to confuse things because it is a long article with lots of detail, some of which may or may not be in front of the jury. And I would be worried about confusing the jury when really what I understand you to be talking about is what you're trying to establish is that the fact that Melissa was dismembered and found in bags was publicly available knowledge prior to 2021. And there are other ways to do that without injecting all of this narrative information that's been wrapped up in a prepackaged by Dateline NBC.
Okay. A couple of things. I just want to backtrack to what you said about self-authenticating, the purpose of it being that the facts in there are true. That's not an authentication question.
I understand it's not an authentication question.
The self-authenticating just goes to, is the source what it claims to be?
I understand, but
we're not entering any true facts. Now, as far as the whole article being coming in, I began this discussion several days ago with Mr. Fawcett. I shared with him the link, and I said, I don't want to put the whole article in. I just want to have a screenshot of the one paragraph that says the body bags. And of course, this discussion is in the course of trial, you know how things go. I haven't gotten a ruling back and all that stuff. So my intention is not to put all these facts before the jury. It's just that one, and that's why along with the link, I sent a screenshot of just the beginning of the article that has nothing more than introductory material and one paragraph that mentions the bags. That screenshot also has the date on there, so I can ask him what date was this published.
Well, then that's exactly why it shouldn't be let in, because he's using that to supplement questions that can be asked of this witness.
I'm sorry, say that again, Mr. Wilson?
Well, he's using the date, for example, the date of the article. He can certainly, as the court has already said, he can ask questions. Are you aware of these articles? Are you aware of these things? Rather than putting in an article itself.
So if I understood your honor, that you would have a problem with confusing the jury, I think providing just a short screenshot of only the relevant information solves the 403 problem.
I'm sorry, I'm trying to find my prior research, and for some reason, the Westlaw is not cooperating with me, so just give me a moment. Okay. Now I found it. So I want to take a look at that. Mr. McDermott, what were you saying, sir? I was trying to look at Westlaw and pull up my prior research.
My apologies for interrupting. I was just appending on to what we had discussed, that you had discussed the problem of confusing the jury, the facts that may not be in evidence, and I think providing only the screenshot with the one paragraph and the relevant information solves that 403 problem, so there's no confusion.
Well, I mean, the screenshot that you've provided says that Mr. Wolfenbarger was arrested on August the 7th. It says he's currently in custody. It says, it tells a story about Christina when she was 3 years old that I don't recall her testifying to. I mean, I'm looking at the screenshot that you attached to your email.
Yeah, I'm a little, don't remember those being on there. Can I approach your honor?
Well, I'm going to share my screen so you can see what I'm talking about. So this
They
is,
have gotten an earlier version of the screenshot.
okay, well, the email that you sent me at the end of our pre-trial conference on
Oh, that's right. The
last
update.
Monday,
Yeah,
that's the screenshot that you sent me, and it has lots of information that is not in evidence and or inadmissible.
that is true. Could I just redact that and leave what's below?
So again, I don't understand why you need this news article to establish the fact you're trying to establish, which is that at least as of May of, does that say 2001?
Yes,
Okay.
2021.
2021, because
And so the point I keep trying to make is that this was published 3 days literally before they went down and interviewed him on this point.
I understand that, but also couldn't you have established that with Calhoun or Shepard?
I didn't interview Shepard. Yep. Yeah, I could have been.
I just mean, there are other witnesses in the case who could, okay, here's the, yes, sir.
I don't want to hold up the court any
Okay.
further. If you want to rule against it,
Okay.
so be it, and we'll move forward. But it's authentic.
No
It's,
question it's authentic, but it still has to be relevant and non-prejudicial and
It is
not,
relevant, but it's prejudicial. I understand that.
and not hearsay or subject to an exception. And just because it can be authenticated doesn't make it not hearsay. And what I'm primarily concerned about is that it has minimal relevance for the concern. I think that the prejudicial nature of the facts that are contained in here, which are either not in evidence or would be subject to some sort of limit. I mean, like I said, I if you were to limit further what it shows, what I think I understand is that the purpose of this article is simply to demonstrate that in 3 days before the police talked to Mr. Wolfenbarger in 2021, there was a news article that said that she was found in bags. And there are other better ways that are less inflammatory and prejudicial than this narrative that's been put together and made all shiny and pretty by Dateline NBC. Okay. Anything else that we need to, and just to be clear, I understand I didn't give you a ruling, but I need y'all to let me know again when you need a ruling, right? Like that was 2 weeks ago. So, or, so.
In all fairness, I definitely tried to make that happen.
Well, I mean, you sent me an email. I understand that, but I've asked any number of times what other matters the parties need me to take up, and at no point did somebody say, "Oh yeah, there's this news article I want to ask Joey Wolfenbarger about," and you haven't ruled on that, Judge. Or nor, in fairness, did the state say, "Hey, Mr. McDermott wants to offer this news article that we object to." Nobody brought that to my attention, so I apologize that we had to do it on the fly with the jury stepping out. But there's a reason I asked 87 times. Is there anything else that y'all want me to address before we do whatever we're doing?
Understood.
Okay, thank you. So are we ready for the jury to come back, Mr. Wilson?
Yes.
Mr. McDermott?
Let me ask one more question.
Yes.
I don't have any other questions for this witness except one. I was going to take previously admitted exhibit, the weather reports, and see if he would be able to read that for the jury. It's perfectly common sense. Any average person should be able to do it. And the detective, it's to a piece of detective who sat there in Hampton Hall and made a big deal about it.
Isn't that document in evidence?
Yes.
So the jury can see it.
Right.
Can they not?
Yeah.
And if it's common sense, won't they be able to figure that out?
So you say no good.
I mean, I just don't know any, I mean, other than that if it's common sense, your average person should be able to read it. But if I recall correctly, the detective struggled a little bit to read it too. And so I'm not sure I understand why Mr. Wolfenbarger, hang on. I'm not quite sure I understand why Mr. Wolfenbarger would be able to understand it and relate that either. Joey Wolfenbarger.
I think that's the point. I think the detective was being dishonest. I think if an average Joe DeCamp can read it, it would impeach the detective's credibility.
Mr. Wilson, that noise you just made is not an objection.
I understand, Your Honor. You're right. I do object to that. I don't think, I think it's been put in evidence. It's already been questioned about. And I think it's been, to have a witness read it when the jury can read it is cumulative, repetitive, and argumentative, Your Honor. So I think it's not, I don't think it would be appropriate for him to do it with this witness in front. I mean, obviously the person he did cross, Detective Callan.
Okay. I feel like you've made, that document's in evidence and you can argue that to the jury and you don't need to inquire with Mr. Wolfenbarger about it, Mr. McDermott.
Fair enough. So bring it back
Anything
here.
else?
I will say no more questions.
Okay. Could you get Mr. Joseph Wolfenbarger back for me, sir? Thank you. Deputy, we're ready for the jury again. Obviously, once we get Mr. Wolfenbarger back on the stand. Thank you, sir. Sorry for that delay. Come on back. And you can just come on back and have a seat on the witness stand. And Deputy, now we're ready for the jury. Thank you all. Please be seated. Mr. McDermott, you may resume your examination.
Thank you, Your Honor. No further questions for this witness.
Thank you, sir. Mr. Wilson, questions for this witness?
Yes, thank you, Your Honor. Now, you were born on July 5th of 1996, isn't that right?
Yes, that's right.
So you would have been about 2.5 when your mother went missing, correct?
That sounds about right.
And you have no personal memory of that, correct?
Not of her, no.
So you have no memory at all of your mother?
I mean, no, like not like a living version of her, no. I mean, there's little bits here and there I can remember, like of the ceremony, but that was it really. I didn't really understand, who she was,
Yeah, because you were only 2.5 when it happened.
Right. I mean, but it was later on when the ceremony and whatnot.
Now you lived with your mother. Well, excuse me, you never lived with your mother.
No, not really, no.
Yes, you lived with Kathy Wolfenbarger, your grandma.
Right.
She wanted you to call her mom.
Not exactly. It was just more so it was easier that way.
So you did call her mom.
Yes.
Okay. And you never saw pictures of your mom at all while you were growing up?
I mean, I've seen some, but they wasn't like displayed all over. There was, the rare occasion that we would go through photo albums or whatnot, but that's the only real time that I've seen them early on.
And those photo albums were located in the house, correct?
Yes.
Okay. And you were 4 when you were told that your mom had been murdered?
I would say that's about right. 4 or 5, somewhere around there.
And you were told by Kathy Wolfenbarger, correct?
Not really. I mean, it was more so of Rachel. Like she got more into detail with it.
Okay.
I mean,
And so you heard a bunch of details
yes,
when you were 4.
yes.
And did you never asked your dad about what happened, correct?
I mean, it'd always been a touchy subject for, talk about anybody, it's not really,
Okay. So you really never had conversations about your mom's death with your dad, have you?
I mean, bits and pieces,
But nothing extensive.
Right.
And that over the years?
Right.
Okay. And after high school, you moved in with your dad,
Yes,
and you haven't had conversations with him about it, only bits and pieces, correct?
correct.
And you were still living with him. You're still living at that address?
I mean, not at the moment, but, I was off and on for a while, shared 2 residents.
Who's the other residence was Kathy Wolfenbarger?
Yes.
Can I just have a moment?
Sure.
Right now, you live with Kathy?
Yes.
Okay. And who is Rachel?
That was the woman he got with after my mom.
Okay. So you've talked about it with your dad's girl, kind of living.
Right. They were living together and they moved in across the street.
Okay.
Yeah.
One more moment.
Sure.
Thank you.
What year were you born again?
96.
96. So when Melissa's remains, or when you went to the ceremony, you mentioned the ceremony a while ago, and you said you had just faint memories from the ceremony. And that would have been in 2003, correct?
Yes.
And so you would have been about 6 or 7 at that point. What have you been 6?
Yeah, give or take, yes, about 6.
So you wouldn't have heard anything about your mother's, how she went missing until after that point, correct?
Yes.
Okay. And is your memory still fuzzy from all that stuff?
Right, right. Like I can remember like bits and pieces, like kind of where we were standing or whatnot, but just.
And so is it safe to say that the discussions you had with Rachel would have come after that point?
Right.
Okay. No further questions.
Thank you. Anything else, Mr. Wilson?
Just very briefly. Sure. Now you have a full sister, correct?
Can you?
You have a full sister. You have a sister.
Yes.
And what's your age difference
10 months.
between you and Chrissy?
Yes. 10 months.
Nothing further.
Mr. McDermott?
I'm nothing further. You may be excused.
Thank you, sir. You can step down and you are excused as a witness. Mr. McDermott, defense may call its next witness.
So, may we approach you?
Yes. Minutes. We're getting your steps in today. Thank you very much.
All right.
Thank you. You may be seated. The jury's clear. Deputy, can you do me a favor and check on the status of efforts to locate that witness or bring that witness here, because that's the next witness they want.
I'll have to go upstairs because I don't have the number.
Okay. I'm gonna, because it's time sensitive, is it okay? I'm gonna ask that we leave that deputy here and you go take care of that while I take up some other matters with these individuals.
He will have, he has to go.
So if he goes, then I can't take up these other matters with these lawyers because he's not here.
Yes, you are.
Ms. German, can you get another deputy in here? Because if you leave, then
I see my call.
thank you.
Your Honor,
Yes, sir.
I'm curious about the rebuttal. I just want to make sure the rebuttal rebuts something that occurred today because we didn't have a case yesterday. So the rebuttal has to be something in response to something that happened today.
Obviously.
I'm curious. I don't think they have to be clear, but I guess I'm preemptively filing a motion that they don't get to just start putting up new witnesses or dealing with issues that came up yesterday or last week, or it has to be rebuttal of today. We didn't have a case before.
I think we all know that that's what rebuttal's supposed to be. It is. Okay. What though of our other witness? They're not here yet. Mr. McDermott or Mr. Samuel, can one of you tell me who that witness is? Because I'm having the deputy check now. By some miracle, thank you, sir. By some miracle, maybe he goes upstairs and finds out that that person is already in a sheriff's car and is on the way here from wherever it was that I saw that they were from, which was, yeah, far away. No, I thought it was out the west side toward Alabama. It's Covington? Okay, so east side. Okay. But that's far. In any event, so let's say by some miracle that person is somehow going to be produced here today. But it's very likely that that person is not going to be produced here in any reasonable time to be testifying today. And so my understanding from you, Mr. McDermott, is that it would be that y'all would be moving for a continuance. Is that correct?
Yes, Your Honor.
Tell me who this witness is and why you believe that a continue to allow that witness to testify.
So one of the undercurrents in this trial has been the relationship between Melissa, Christopher's family, Melissa, and her family. A huge part of that is this custody battle, and I think the jury's going to have to decide at some point. One side was pressuring her to do this, and one side she wanted to be with, or maybe there's some other complex dynamics. In my opening statement, I gave basically said that the evidence is going to show that there's strong evidence of a very poor relationship between Melissa and her mother at the early stages of her life that ended up leading to her running away. Okay. The state has been able to counter that by presenting these evidence of these cards and the letter, et cetera, et cetera. But I have relied upon this witness to provide the evidence I need to sustain what I told the jury it's going to show. And I think it's a relatively important piece of evidence to show that she did have a poor relationship with her mother. And so this witness was a next door neighbor to the Wolfenbarger, or to the Pattons, sometime in the 80s up until maybe the early 90s. She was best friends with Melissa. She is going to testify that all the things I said in my opening, including some that are arguably worse. That they were locked in their rooms, they were not allowed to leave to get water. Melissa was not happy. Melissa began running away with her. Eventually, on at least one occasion, did drugs with her and got into some other things. And she's going to testify that the locking in the rooms specifically went on from about age 7 until about age 12, every day that she came over there, all day. And there's a considerable amount more of a backstory to that. So, and then at some point after the finding of the baby, Melissa started running away.
Well, that's in evidence. I mean, that part very clearly is in evidence. I've heard people discuss it multiple times, and not just through lawyer questions.
I don't need her to establish that point, but it does establish it in the context of the timeline of what she calls Melissa's neglect and abuse. She will also testify that there were times that at some point her mother would not allow her to have makeup. She had to use colored pencils on her eyes. She's going to testify that her mother would not give her feminine hygiene products, that she had to use socks for pads. And I think those are all relevant as far as illustrating the relationship and the feelings Melissa would have had to her mother. I cannot fulfill what I said in opening statement without this witness. And so I think for that reason alone, not to mention the extremity of what she's going to testify to, I think it warrants a continuance if we need to have it.
Do we have any information about why she's not here?
I do. So when I initially contacted her probably 2 weeks ago, I was actually shocked that I finally got through to her, and she was effusive to me. She was like, I want to tell my side of the story. I want to tell this. She's very clear. She's not a fan of Chris, and she's not on his side in this trial. But that she said, I will show up and tell the truth. I said, well, would you testify? She said, for him, no, but I will tell the truth. And I said, if I subpoena you, will you come? She said, yes. And she, on a couple of occasions, kind of went silent as I was trying to communicate to her what days to be here. But she came back a couple evenings ago and told me that because I think it was her stepson died at the beginning of July, she's been dealing with depression and things like that, and that she just needed to spend a day or two in bed. But she texted with me. She sent me a bunch of pictures of Melissa and then growing up. She was very open about it. I shared with her that, if cost is a problem, we're allowed to reimburse you for certain things, travel, whatnot. And she said, oh, okay, fine. And it was clear to me at that point she was going to come. And then yesterday, she didn't come. And then I contacted her last night, and she gave me a hard, trying not to use the word she used, but it was basically
not just no, but
I think she realized that what she has to testify to will help Chris in some way, and so now she's refusing to come. And I did not tell her I was going to send the deputy because I don't want her to run and hide somewhere. And that's the long and short of it. So the short story is that it was not until the day, or I think it was early this morning, not coming, and variations of that.
Okay. So realistically speaking, though, I mean, let's play this out logically. Are we confident that even if a deputy did go to her house and force her to come here, that she would willingly testify? I mean,
I fully expect she's going to be resistant. I would ask for her to treat her as an adverse witness. I have our conversation recorded, and I've made a transcript of it. So I am prepared.
Well, if she's refused to, well, she wasn't. I mean, she isn't available if she's refusing. But anyway, what are your thoughts, Ms. Hilton, or somebody from the state?
I'll just add, if the state will waive costs, we'll be happy playing portions of the audio.
That won't happen.
She said that won't happen.
Your Honor, we don't necessarily object to a continuance if this witness is under subpoena and can get here. So we're not opposed to the continuance, Your Honor. We would ask if we can have a copy, at this juncture, can we have a copy of the recording and the transcript of this witness interview so that we can prepare. So that's
It
what
was
we-
sent 2 days ago, Your Honor. They have an email.
You mean you emailed them the audio file?
Yes.
Thank you. Okay, so one other question that I had asked counsel at the bench, I mean, it's less than ideal, but if there is a chance, which I'm going to wait and see what I can hear from the state, or excuse me, from the sheriff's office about any progress that's been made to locate this person and go get her. But if there is rebuttal, is it possible we could just go ahead with rebuttal and come back to this witness if we can get her here later today?
I would not prefer that because I don't know what she's going to say, and my rebuttal witnesses may need to address what she's going to say, and so I wouldn't want to start giving my witnesses.
In fairness, Mr. Wolfenbarger did pretty much tell you what he was going to. I mean, it sounds as if the only knowledge that she could have if she knew Melissa when she was a kid is Melissa didn't get along with her parents and some specific facts about it.
But we never know what's actually going to come out on the stand. So we understand the recording, we understand what his proper is, but I don't know what she's actually going to say, what's actually going to come before this jury. And so the state would prefer to have the defense finish their case, and then the state move forward with rebuttal at the conclusion of their case.
Okay. Yes, Mr. McDermott.
Yes, Your Honor. Your patience is unlimited and admirable. And there's no reason they couldn't go ahead with the rebuttal witness. And if our witness is here or not, we can still hold her over to the next day. I mean, I'm saying we can still do the rebuttal if they want to.
Yeah, I know. So I think I know everything I need to know except for what effort, if any, has actually been made to go and find that person. So at this point, we're just going to have to let the jury cool their heels for a minute until I step off the bench so that Deputy Holt can go check, because for some reason there's not two departments that do that, right? Or Miss Deputy Holt is stuck doing it himself, even though he's also got to be in here doing this part of the job. So in any event, I'm going to take a break for a moment so that Deputy Holt can step out and see what the answer is about this witness. And then I will come back and we will figure out what to do. I will tell you that I don't love the idea of a continuance, but if there's some reason to believe that she can be gone and gotten, and all I need to do is delay until perhaps in the morning, that's not unreasonable. But this case is going to the jury tomorrow. I mean, I just don't see a universe in which we can justify, for what sounds to me like relatively narrow topic of inquiry for a witness, delaying this jury beyond having the case tomorrow. But I might consider a continuance tomorrow if there's some reason to believe that she might be gotten and delivered here and cooperative. So anyway, I'm gonna step off at 3 o'clock. I'll come back in maybe 10 minutes when hopefully Deputy Holt has some information for me. Thank you. And I'm told that they're also going to notify Newton County, which is, and ask Newton County to write out, which is where Covington is located, I think. And that they believe that they will be able to provide the court with an update by, certainly before 9 tomorrow morning, that either they have secured the witness and are prepared to deliver her to the courtroom to testify, or that what I think is likely realistic, if she's that reluctant, is that they went to her house and knocked on the door and nobody answered. And that they have attempted to secure her and not been able to. So for that reason, if the defense's request is that we have a continuance until tomorrow morning, then I'm inclined to give one. But as I said before I left, and you can make whatever record you want to make, I would not be inclined to, as long as a reasonable effort has been made to execute that warrant and secure that witness's presence here, I wouldn't be inclined to delay things any further beyond tomorrow morning. Questions, thoughts, concerns on that issue, Mr. McDermott?
Well, you've basically already given a ruling. I mean, your inclination is your inclination, but I think the witness is important, given what's on the record and what we need to put on the record. And I subpoenaed her a long time ago. This is, I've made a great effort to secure her to be here. So, I would request, I understand the logistic aspect of it and difficulty for the jury and whatnot, but I would request a continuance at least through Monday, if need be.
To do what though? Right? If the warrant division, if the warrant division is going to go to her house and either interact with her and say, come with us, or you have to appear, or get no response, then what would delay? If they're going to do that tonight and report back to me that they did that one way or the other, then what would there be a need for a further delay?
I mean, yeah, obviously you can't know if she's just not answering the door or if she's fled somewhere. So.
Right. And I don't know anything about her criminal history, but I don't, my point is it's a witness warrant, right? I mean, so yes, she hasn't complied with the subpoena, but.
I mean, you have more power than just to grant continuance for one day, though. There's lots of contempt power there that you can use. I would request that there be more than one effort made knocking on the door. That's all I'm saying.
Okay. And that's really what I was trying to get to, is what else would you have me do other than what they're going to try and do tonight? So I understand further efforts.
I'm sorry.
Go ahead.
I'm really sorry. There's a provision, of course, in the evidence code in the same section on enforcing subpoenas that says that in such cases, secondary evidence may be used to supplement their. I know you can't give an advisory opinion, but I already talked about possibly playing portions of the tape. I'm not sure what other remedy there might be in that regard. I would be happy to hear your thoughts and anything you've done in the past in that regard.
Ms. Holt, what are your thoughts, ma'am?
Yeah, we would be objecting to any, I guess, a couple of issues. So one, as far as the continuance, the state doesn't object to it, continues to 9 o'clock tomorrow morning. At that point, I think I was taught in law school, don't make promises in the opening that you don't know if it's going to happen or not. And so, Mr. McDermott keeps saying, I made these promises in the opening, I made these promises in the opening. I don't think that determines whether or not this case moves forward in a manner that the court wants to, just because he said it in opening. As it relates to playing portions of this witness statement without the state being able to cross-examine, Your Honor, I think that we would be objecting while she might be unavailable. We never had an opportunity in any previous hearing to cross-examine this witness. And so we don't believe that the unavailability hearsay statute would apply in this case because we haven't had an opportunity to cross-examine her. The statement we believe would be improper.
Okay. And then the next question is with or without that witness, right? If the defense either has that witness and has her testify or doesn't have that witness, and then I guess calls any other witness it may or may not have tomorrow morning. And then I guess we're going to delay the state's rebuttal until tomorrow.
Yes.
Okay. Have you actually had an opportunity, not that I'm necessarily inclined to, given the vagaries of what's been represented to me, but have you had a chance to actually listen to whatever that witness has said and whatever recorded statement Mr. McDermott provided to you?
I just started listening to it. I'm probably about 12 minutes in, so I have about 21 minutes to go, Your Honor.
Okay. Okay. So I think what I'm going to do is excuse the jury, have them go home and come back tomorrow morning at 9 or 9:30, excuse me. And we will expect either a witness or the defense to rest. And then the state will have its rebuttal, which we've already discussed. We all understand will be rebuttal of something that the defense actually put on or created an issue about. And then we'll plan for the jury to get the case tomorrow. In the meantime, after I send the jury home, I would like to have the actual charge conference and any other matters that we need to take up. Anything else that y'all need me to address before I bring the jury in and send them home?
Nothing from the state, Your Honor.
Nothing from the defense.
Okay. Can I have the jury, please? Identify any typographical errors or anything, please bring them to my attention because I like to fix them where I can. Some of them y'all have already brought to my attention. grave suspicion, which was requested by the defense. Witness impeached. We discussed witness supported, which we agreed to jettison yesterday because it hadn't been, no one had attempted to rehabilitate a witness in that manner. We didn't actually discuss tailoring of witness attacked, but tailoring it to the evidence, I didn't hear, thank you. I didn't hear anything about, certainly I've heard some intimations of bias generally, but I've not heard bias in the particular way that it's contemplated here. What are your thoughts, Mr. Samuel? I don't think it should be there is my point. I've not heard, while I've certainly heard general implications of bias based on parties' relative alignments with one another, I've not heard bias demonstrated in the particular manner that it's contemplated by this instruction.
The state agrees, Your Honor.
State what?
Sure.
I'm just looking at 131. You don't mind if we sit down, correct?
No, yeah.
The original version had 3 bullet points. I'm trying to figure out what happened.
Right, but well,
First
because
one's gone.
the first one's completely gone because nobody had any testimony about reputation for truthfulness.
Okay.
And this one is highlighted because I thought it was a closer call because obviously parties are always going to talk about that people have biases. But this bias is supposed to be presented in a particular way, and I've not heard any such evidence.
I see what you mean. Okay, so instances of conduct of the witness, right?
Right.
I don't see that.
So my inclination would be to take it out, and the only one that would be in would be criminal convictions. Excuse me. Prior statements. Okay, so Ms. Hilton, I had discussed with you yesterday this issue of immunity or leniency granted a witness. Mr. Samuel has made the argument that the case law is that the grant of immunity is so broad that it is essentially in service of any time that witness ever testifies about those actions, and therefore it's a relevant consideration. I had expressed yesterday that I wasn't sure if there was any particular case law on this point, but that at least from a plain language perspective, the pattern charge is written in a very, very general sense.
Of course, another for one moment.
Sure.
While they're talking, can I ask a question? I lost track of, is what's on the screen going to be in numerical order? Are you skipping?
No, they're in the order.
So 131.42, which is witness supported, is out. Witness impeached one. So that's
So
what's on the screen.
131.45 is just the standard. This is what impeachment is.
Okay.
It's a little bit out of order because to me, you need to tell a jury how to impeach what it means to impeach a witness. And then witness attacked is there, but witness supported has been removed based on our conversation yesterday.
And you have prior statements.
Yep.
Okay.
And now we're on immunity.
Got it. Okay.
Your Honor, I didn't know if the court had a chance to consider the lead case and what. I think what's a fair characterization of the case law is that it is not error not to give the immunity or leniency instruction. We feel that in this case, this is really meant, and if you look at all the case law, and there's plenty of case law in Georgia with Lee and a bunch of other cases from the Supreme Court that say that it's not error not to give it. I think that we feel like that unfairly having its own instruction is an unfair emphasis on immunity and leniency, which is a very, very minor part of this case. Whereas it is adequately covered under the prior instruction based on credibility of witnesses, Your Honor. We feel like that having extra instructions in general runs a risk of confusing the jury. I don't know. This is relatively clear. I'll admit that, but we do feel like it unnecessarily highlights that. I don't think you need to give it. This is not the same thing. That is meant for a case where a co-defendant has got immunity. I mean, that's really what it is.
Right, and we discussed that yesterday. I agree with you. That's typically where it comes up, but it is written in such a general way. I will say this, though, to your point, Mr. Wilson, Mr. McDermott or Mr. Samuel, I mean, even if the court doesn't give that instruction, you're still allowed to argue that she got immunity for assisting her husband in murdering people, right? The argument you're going to make regardless of whether I give that charge or not.
Yes, but this is in the credibility of a witness based on being protected by the immunity, not that she's a bad person. This instruction deals with the fact that she was rewarded for testifying and is still under that protection. She's still protected by the immunity she received. If she
Right, but it's not immunity in this case, is their point. And it does so in theory, it doesn't, in theory, it would be lesser likely to influence her testimony here, I think is what the state is saying, because
there are so many parts of a jury instruction which
aren't the most important part of the case.
Sure.
I mean, most of all of this impeachment and witnesses and, are not critically important issues. They're just overall view of the types of things the jury can consider. Inconsistent statements. When you're talking about a credibility of witness, why bother talking about inconsistent statements? Why talk about prior statements and stuff? It's because you're giving an overall view of the types of things the jury can consider, not required to, but can consider in evaluating the credibility of witnesses. I don't think we should take out something just because it's not error to take it out. We should only take out items that are just completely irrelevant to the consideration of the case here, like we've been doing with a couple things now.
Okay. I'm going to look at it again. I did look at the general case law. I mean, again, I don't disagree with the state's assessment that this is typically intended for where a party in the case who's testifying has gotten immunity related to the case. And I also don't agree with you that the case law says it's not error to not give it, because you can still make an argument. Even if I don't give that charge, the defense can still argue.
Well, yes, Your Honor. I just don't think I think the case law is clear. It's not error for the court to instruct the jury.
But that's what I just said, right? I agree with you that it's not error to not give it.
Okay.
But I'm still not sure under the facts of this particular case that it's not implicated and that it would not be proper. So I'm gonna put a pin in that one and give you an answer in the morning. Okay. Single witness, defendant's choice not to testify, prior difficulties between the parties. So I would like to have a discussion on this topic because I think that although we have spoken in the generic about the prior difficulties that are alleged by the state between this defendant and the victim in this case, what I actually ruled was that those facts about those prior instances and allegations of physical altercation or abuse between the defendant and the victim were intrinsic evidence. And the law is clear that intrinsic evidence can be considered for any purpose once it's admitted. And this instruction says that the jury can only consider it to the extent that it demonstrates the state of feeling between the defendant and the alleged victim, which I'm concerned confuses the jury between the purpose for which they can consider it or not. Having said that, I also think that it might make sense to err on the side of giving this charge because the limited nature of the consideration might be better. I don't know. I do have concerns about it. I mean, as I said, the law is clear as far as I'm concerned. Although prior difficulties, there is no case law that I can find that gives me a Venn diagram between prior difficulties and intrinsic evidence. There's some discussion in Carlson and some other things that, yes, the federal treatment of it and the state treatment of it are that prior difficulties are likely treated as intrinsic, but no discussion of the dueling standards that might apply. Because again, if it's intrinsic, then it can be considered by the fact finder for any purpose. If it's truly prior difficulties evidence, then it's limited in the manner that is described in this jury charge. Thoughts?
Well, I think I expressed my thoughts yesterday that maybe it's protecting the court as much as anything. It is if in fact the court says some of this is intrinsic, some of it's not, and some of it went back years. Some of it, we don't even know what time frame they were talking about. If there was prior difficulties that were some of the earlier ones at one of the earlier Waffle Houses that goes, I think, before even July of '98, rather than being intrinsic, that may have been would fit more within the Venn diagram part of prior difficulties, and at least we're protected from that. The real point is we don't want a jury saying you're guilty of murder because of the way you treated her before. That's the whole point.
Right.
I don't even know with intrinsic cases it wouldn't be improper. I mean, there is an instruction much later on. You can only convict him with that with which he is charged.
Right. It's
really reiterating that in this context. What happened to 13400? Did we just skip over that? Or
130.
13400. It just says limiting instructions?
There is not a 13400. I think it's just a general proposition. Well, I'm sorry. Because there is no 404B evidence, there is no need for the general limiting instruction charge. I apologize.
That with all the similars, right?
Yes. Okay. So hang on. No, I've lost
there it is.
Thank you. So yesterday, the defense has requested this charge, and yesterday the state indicated that they didn't have any objection to giving that charge. I think there's probably a reason to consider giving the jury the charge, because whether it's, I've ruled it's intrinsic, but it is in the nature of prior difficulties between the two parties. And so if the state doesn't object to the defense's request that I give the charge.
When I'm trying to just think through kind of what the court just said, because we have case law like Flowers v. State in which prior difficulties between the parties could be motive or could be they're coming for other reasons other than
because it's intrinsic,
right? And so,
well, Flowers is a 404B case. To be clear. Well, there's two different Flowers, but one of them is a 404B case. It says even prior difficulties have to be evaluated under 404B. You don't get notice. That's the weird difference between prior difficulties and 404B.
So then the question becomes: do we get 13420 and go back and get 13410?
Hang on.
you find Hughes again, if it pops up, I can't find that citation for some reason.
Sure. So the purpose of the 13410 instruction, as I understand it, and please, I don't want to make an error. If you think I'm making one, tell me. But the purpose of 13410, as I understand it, is where you are limiting the use of that evidence. And my understanding is that when the court has ruled that evidence is intrinsic, i.e. necessary to tell the story of the murder itself, which right or wrong, I have clearly ruled that that evidence was intrinsic, there is no basis to limit the jury's understanding or use of that evidence. They are allowed to consider it for any purpose to which it is relevant and admissible in the case.
So then we would ask for 13420 not to be given, so it does not limit the purpose for which we introduce the intrinsic evidence of the prior difficulties of between Mr. and Mrs. Walker Bogger. So we ask that you not get 134.
Okay. Mr. Samuel, your position is you do want it to be given, correct?
For sure.
Okay. Right now it's in, and that's gonna be my additional homework. Let me give you the Hughes case before, now that I have finally gotten my history on Westlaw pull up.
Yes.
Very bad at navigating my history. Give me a few minutes and I'll find it before we call it a day.
It's my responsibility. You had given me 296 Georgia something, and I just couldn't. And then I tried to search Hughes plus intrinsic, and couldn't come up with anything.
Yeah.
But that's okay. Why don't we keep going through it?
Okay. Let me go back to my jury charge. Okay.
If you don't mind jumping back and forth, I just found Hughes for you.
Thank you.
312 Georgia 149. I believe that's the case you.
Well, I want to look because there was, the case I was particularly looking at was one particular prior domestic incident. And when I was just looking now, I found another Hughes case that involved 3 brothers, and I'm not sure that's the case I was looking at. So I wanted to find it again, but it was specifically related. It talks about both prior difficulty and intrinsic. And it was, the admission was specifically related to a prior incident of the defendant allegedly slashing the tires, I think,
Oh, I saw that.
of the victim.
I ran across that this afternoon when I was looking. It just didn't seem to be as. Anyways, my issue. So,
Okay.
So 13430, yeah, that's next.
Yes, and I have tailored it. Right now, the only evidence is evidence that witnesses have prior convictions, and so I've tailored it just generally to that. So we had some discussion yesterday about identification, and there was a discussion of whether or not to give 13510 or some portion of it. Obviously, The second portion of 13510 is very clearly directed at people who are, stranger observations of, wrongdoers, alleged wrongdoers. And that's not really what we have here. The more I looked at it, the more I thought, if we're not going to give that portion of 13510, is there really even any point to give 13510 when 13511 says it's the state's burden to identify this defendant as the person who committed the offense, which is really what's at issue in this case.
Yeah, sure. We were going to, I'm not sure if the state requested it, or we were going to withdraw 13510.
Yeah, I think it's pretty standard for the state to request both of them. And so, yeah, I will remove 13510 with everyone's agreement. Okay.
On 13430, because there are no prior convictions against Mr. Wolfenbarger, because he just had misdemeanor. There was no felony against Mr. Wolfenbarger was introduced. You said against any, well, what do you have? Just a witness?
Yes, it just says that it's been tailored. You have received evidence of prior convictions of witnesses who testified in this case. You may consider this evidence only insofar as it may relate to attacking the credibility of the witness and not for any other purpose. And then definition of crime, intent, no presumption of criminal intent, presumptions and inferences, malice murder, motive, felony murder, causation and felony murder, aggravated assault with a deadly or offensive weapon.
Did you correct the typo on 21030?
I believe I did, where it said they, it now says he.
Okay.
And then there was some discussion yesterday that I don't think, setting aside for a moment, that's still pending, DV motion regarding this issue of the offensive weapon. Do you have any, let's assume for a moment that I'm going to deny the motion for directed verdict and that the issue of felony murder based on aggravated assault is going to go to the jury. Typically, the charge of aggravated assault is accompanied where it's not like with a deadly weapon or a handgun where we all know it's a deadly weapon. It is accompanied by this charge, which I believe was requested by the defense. Any objection to that charge?
Or don't 22023.
Yes.
No objection.
Okay. Then you generally, the verdict, multi-count indictment, alternates, etc. That's the entire charge. So I think, if I'm not mistaken, the parties are in agreement with the exception of the court's ruling on the immunity charge and the court's ruling on the prior difficulties charge, which as it currently exists, the defense has requested, but the state objects to. Is that correct? Any other charges?
I am on the offensive weapon. That seems to me the same issues that are causing some concern about the directed verdict motion, why it doesn't apply to the jury instruction also. It seems to leave this so open they could decide that the act of dismemberment, the saw, was the weapon used, but that's not really in dispute. I
don't think so. I think the ME pretty clearly testified that those were post-mortem.
State must prove that the defendant assaulted another person with an offensive weapon. And caused the death. There's no display of anything to the jury. How is there any manner in which it was used? There's just no evidence of that at all. The character or capabilities of the weapon.
I agree, which I expressed during my discussions with Mr. Fawcett about the directed verdict motion, which is, like I said, even assume for a moment that I'm like, okay, it goes to the jury. There's literally no evidence of a weapon. I understand the state's argument when we were having the directed verdict discussion was, well, she died in a way where we've presented facts that, could lead, a reasonable inference could be drawn from those facts that she died by homicide. And so then I guess, and I agree with that, right? Which is why I denied the motion for direct verdict on the murder charge. On the felony murder, secondary, with an underlying felony of aggravated assault, that's what I'm still struggling with for purposes of instructing the jury as well, which is, how can a jury make a reasonable inference that a weapon was offensive if there's literally no evidence of a weapon? And I think I understand the state's best argument is that a weapon, in the very broadest sense, had to have been used to accomplish the death, even if that weapon was, I think your example was poison or something.
Right, and not only that, but I think getting back to the root of the evidence that came out, the reason why we aren't able to make those determinations is because the state in which the body was disposed of, and ultimately, I don't know how that's not akin to essentially not we have that intent, but rewarding the defendant for doing a good job and it's difficult to make that determination. I think that there are facts and evidence. The judges, Your Honor, is going to give the jury a definition of offensive weapon, and it's up for the state to convince the jury that there is an object or enough facts and evidence that the jury can make those reasonable inferences that an object was used, and it fits that category that the judge is going to define as to what an offensive weapon is. I think that there is testimony from Dr. Gilbo, Dr. Terry, the investigator Miller, not just as the photographs, but the injuries, the manner in which they believe that the body was dropped off and murdered at a different location, that it wasn't sacked up at that location. I think all the facts in this case not just point to a homicide, but a homicide. We never said that she was killed with the saw, although that is still a possibility. She could have been. but we don't have the parts of her body that are necessary to make those determinations. And we don't have them because the defendant disposed of those parts. And I think that the jury has enough facts before it to make all those reasonable, common sense, logical deductions.
Mr. McDermott?
Your Honor, the state has to prove its case beyond reasonable doubt from evidence, not from a lack of evidence. What he's arguing for is, court, please allow me some leeway so that I can prove this without any evidence. And if you don't, you're giving a windfall to the defendant because allegedly he hid the body really well and didn't leave us any evidence. That's not how this works. There's got to be evidence.
Well,
And you can't just say, well, leave it an open door so that we can let them assume any possibility, like poison, et cetera. That is directly contrary to how this is supposed to work.
well, it seems as if I have some additional homework to do tonight, but I already did because I took it under advisement. But
Can I make one last correction?
sure.
This is nitpicky, but I think the statute warrants it. 13020 on direct and circumstantial, the last paragraph. Pass it.
13020.
You're right, right. 130. The last paragraph excludes all reasonable theories of innocence. The statute says hypotheses. And I would request that be changed.
Okay. I will take a look at this. There are two versions of that pattern charge. There are two versions of the direct and circumstantial pattern charge. There's the long version and the short version. This is the short version, number one. Number two, this has also been plain language by the plain language the pattern jury instruction plain language committee. So in an effort to get rid of big words and use words that are readily accessible is, I suspect, likely why hypotheses isn't there and theories is. But I will take a look at that.
Thank you.
Anyway, all I was going to say, and I don't know that I'm saying anything that I haven't already said, but to be clear, the reason that I'm taking under advisement is I've already said I think there is evidence here that is sufficient to require the jury to determine if they believe that a murder occurred here and that Christopher Wolfenbarger committed that murder. Where I am having some reservations that I think I've been pretty plain about is, while there are facts from which a jury might determine that a murder occurred and that Mr. Wolfenbarger committed that murder, aggravated assault requires that there be facts from which a jury could understand how that murder occurred and the manner in which it occurred. And that's what I'm struggling with because there is no evidence of that. And the mere fact of death, I understand the very broad way in which the state wants me to interpret the aggravated assault standard, but I haven't finished looking at it yet, but the defense is at least urging that the broad way that the state wants me to interpret that aggravated assault isn't as broad. They're not actually allowed to have it interpreted that broadly because, for example, and again, I'm just saying this is what they've argued yet because I haven't had a chance to spend some time with it, but that other methods of aggravated assault are not available to the state, like aggravated assault strangulation or other things. And yeah, well, that's why I mentioned it because I don't know that I'd heard a clear response from the state on that point.
Well, I would like to pose an hypothetical for the court to consider. I think if I could.
Sure.
So I would say let's say we have an example where an individual is found deceased and they have a significant injury to, say, their head, and you have another individual that just no other evidence, but they confess to it. I did it. And you don't have any other facts with that. You ultimately would have evidence not of an object. You wouldn't have evidence of a weapon that was used. All you would have at that point is the confession tying the person to the crime, the injury to death, and then you would have the injury itself. That's the only thing that the state is missing in this case is a visual depiction of that we could say definitively where whatever impact happened. We don't know if it's bruising on the neck. We don't know if there were hand marks that she was choked. And that because of the state of her, we don't have the marks on her neck to show the jury, hey, this is why we believe she was deceased or asphyxiated because she's got these marks on her neck.
So forgive me for interrupting, but two things to your example. Number one, I'm not sure I agree that example is apt here because if you had a significant head injury, like for example, if the skull in this case was distended in some manner or injured in some manner, then the existence of the injury, right, could be used as some evidence of the offensive nature of the weapon that was used to cause a violent injury or an attempt to cause a violent injury. And that's number one. But number two, and my real point is what you just said, which is you've mentioned a couple of times whether there's bruising on the neck or if they use their hands around the neck. What I haven't gotten a clear answer to from the state is a response to the defense's argument that ag assault strangulation is a different crime that is not charged in this case, and the state can't argue it.
It is a different crime, but aggravation strangulation can be charged with regular aggravated assault. It can specifically be charged with aggravation strangulation, and the state would be authorized to make all those arguments in closing argument. So I don't think that specifically charging it with family violence aggravated assault or aggravated assault strangulation prevents the state from charging the cases as a plain language aggravated assault in both those instances and still prosecute for the jury. So I don't think that charging it specifically as a strangulation prevents us from arguing that that's one of the possibilities that you could have been verdict on one of the matters of death. That the charge of aggravated assault is meant to be brought, especially when there's an issue as to the date in this case. There is an issue as to the date, especially when there's an issue as to being able to prove what type of object. We're going to have this issue anytime. There is the lack of evidence because of the actions of a suspect or a defendant. This is always going to be an issue, but that is why the statute phrases the options as offensive weapon per se, and it specifically relates and mentions objects because it says objects because there are limitless. Depending on how the objects are used, it could become dangerous, cause serious injury. And that's the point that the state's making. Ultimately, is that this is not like any other situation where we have pieces of evidence that's missing. The jury has the facts to make those conclusions based off of all the facts in the case. The injuries that occurred before, the injuries that occurred throughout the year, the manner in which your body was disposed of, the manner in which it was assaulted and cut, dismembered. And I think that all of that is something that the jury should be able to consider in that determination as to whether or not the statement is burden of proof of the
Okay. So just to be clear, so I know what my homework is. I'm going to look at the immunity charge. I'm going to look at the prior difficulties charge, the theories versus hypothesis in the circumstantial evidence charge.
Mine's easy homework.
And I already have under advisement the DV motion on the ag assault felony murder. And I will say this, if I allow that charge, that count to go to the jury, I expect that what I will do is give the patterns that are here and let everybody argue about what the questions that those patterns beg, right? That the state doesn't have answers to, that I've heard from the defense. So.
Your Honor,
Yes,
I
ma'am.
am looking or researching. I know that we've had some statements come in, prior inconsistent statements come in. I know we have the prior statement charge and rules of credibility, but specifically that the prior inconsistent statement can now come in as substantive evidence, and so that they can take what the prior inconsistent statement was as fact or as substantive. And so I don't believe that the prior statements charge adequately addresses that. So I'm just trying to, and we don't have a pattern charge on that specific topic, so I may be emailing the court.
Okay, that's fine.
Non-pattern charge.
Okay. I mean,
I looked for prior inconsistent statement with the substantive portion. I didn't.
but that's, I mean, that's because it's a relevance ruling, right? Prior inconsistent is whether it's coming into evidence because it was disputed. And I believe those statements are in evidence, right? So the question is to tell the jury what to do with them. And I think the issue is go back and look at the prior inconsistent statement, or excuse me, the prior statements charge. I think that the pattern discussions indicate that it was intentional to do a broader, more general statement about the purpose of prior statements. And if you look, it doesn't say that you can only consider it for its, inconsistency. It's for you to decide why they would have said one thing before and said something else now. So I believe that that's why there's not a pattern that specifically highlights that it was inconsistent or not inconsistent, et cetera. But if there is other language you want the court to consider, I will of course consider it.
Thank you.
Anything else from anybody before we adjourn for the day? Okay. I will see you guys in the morning at 9:30. Yes, ma'am. Seat, if you'll turn around and face the deputy and raise your right hand, he'll swear you in, okay?
Raise your hand, please. You swear, I'll answer.